Hey guys! So, hope you're having a great weekend so far. We are going to kind of rewind a little bit and go back and watch certain parts of the YSL trial. Today, I think we're going to start with Detective Gaither. Detective Gaither was on the stand for, I think, like 8 days, but some of those were half days, and you guys will get to see a good idea of what Glanville time and Love time looked like if you got to miss that earlier in the trial and only came in after Brian Steele was held in contempt. So I imagine half of you are probably familiar with this testimony, and the other half it's going to be completely new to you. So we're going to watch it on a faster speed. If it's too fast or too slow, you guys let me know. And as general housekeeping, Kayla Bumpus is doing an interview today with Courtney Kramer, who is running against Fani Willis in the upcoming election. So this is a link to that live stream. It starts in about an hour. So if you guys want to bookmark that, check that out. And we'll be here, I don't know how long we'll be watching today, but, 2, 3, 4, 5 hours, we'll see. Shout out to everyone who's here waiting. This is super cool to see. Jason in the chat, very, very cool to see you. Shout out to Rochester. Be careful with, clothing line named Body Bags. They're going to say that that's drip. They're going to call it Rico. Be careful, but super, super cool to see you. Hey to Frandrew, Steph, Sapphire Ridge, Trakisha. Always good to see you, for always, forever, for life. Lacey Ann, Biff, Aaron, Olivia, Christy, Roy, you guys are using all the emojis already. Jim, Hope, look at all the regulars. Look at all the regulars in here. Hello, hello to everyone. Hey, Factual Eye. And hey, Julie. Hey, Taylor. Hey, JC. Good to see you guys. So we're going to get started again. You guys, let me know your feedback on the speed, if you want it faster or slower. We're going to start with Love arguing why Detective Gaither shouldn't be shown on camera. And then we'll get to her being actually called. So here we go.
All right, is the state's next witness outside, madam? Yes. All right, okay. Our jurors present, sir? Yes, sir. Okay. Madam.
Will the court address the matter that we requested consideration for?
In terms of what, madam?
Okay, Kayla's interview's tomorrow. Oops. Not today.
Madam. All right, Ms. Love, go ahead. Mr. Adams, and I don't think you can be heard. So could you repeat what you said, please?
I ask that the court allow us the consideration that we requested at the bench before we broke for at least the remainder of today, until such time as the court can hear as it wishes from the witness themselves regarding the concern, or until such time we can just for today.
Okay. This is again why we couldn't have taken this up at an earlier time, or you couldn't let me know this so I could go ahead and rule upon it earlier?
Your Honor,
with all due respect to you, madam, and your witness, you did ask, okay? But at this point in time, I'm inclined no. I'm inclined not to at this point.
Your Honor, would the court allow it to be heard from the witness?
We should have heard that days ago. Has she been threatened, madam?
As I explained at the bench, and I don't want to say a whole lot, but as I explained at the bench, because of the nature of the work that was done and because of the lack of the protection that carrying the shield would normally provide at this point, we were asking for that consideration that was given to a similar witness in her position who is still afforded the protection of the shield. So we asked for that reason because of the extent of the involvement that she had in particularly sensitive matters that she will go into today and that the court can hear before the court makes a decision about the rest of the week. We were asking for that small consideration for the next 30 minutes or however much time we'll be in here today.
Madam, I'm supposed to have a hearing on that. I am. You know that under Rule 22, I'm supposed to have a hearing on that issue.
Your Honor, if there was a media person who was insisting on that, but Your Honor, we've talked things over with the media previously about other matters, and they don't have the objections that counsels for various and sundry defendants are leveling. They don't have those objections. So they are the ones with that ability and with that right with respect to Rule 22, and they have not been leveling those objections.
All right.
So.
Anything further?
No, we're just asking for that consideration.
From the defendants, anything further? Counsels?
Other than what's talked about the bench.
Hardening guns of caution, Mr. Matthews. I certainly don't want to put anyone in the particular position of being targeted. And I believe that
This witness.
for this particular witness, I believe that is a grave concern given her involvement. So I'm gonna err on the side of caution. Over your objection, I'm gonna allow her her face not to be shown, but she can be videoed. She can be audioed to that extent. All right?
Thank you, Your Honor.
All right, summon your witness. Oh, wait 1 second.
After that,
What is it, Mr. Steele? I'm sorry.
Sir, I just wanted to perfect my objection to the Daubert hearing not being held.
I thought you did that at the bench.
No, we took the break, not we, you.
No, I thought you did that before we took the break, because you did say about why you objected, and you asked me to have a Daubert hearing. I told you that given the citation I was given.
Remember, Daubert is when someone's going to be
and you
qualified
cited
as
me
an
Harris,
expert witness.
In terms of your position, it was the court's position, taking a look at United States versus Ware, that the Daubert hearing was not necessarily required, that the state still would have to prove the foundation as to the requirements and admissibility in the court's gatekeeping function. And I'm sure that if they don't prove that, you will ask me to exclude that witness before you have an opportunity, and you'll still have the ability to voir dire that witness.
Can I just simply put this on the record that understand?
Yes, absolutely. But I wanted to let you know, that's what I heard at the bench. So what else that you did not tell me?
Okay, so I think you know, I think we discussed at the bench, it wasn't me, but there's no report that I have from Detective Gaither.
Okay, we took up that already as well.
Just this one.
Okay, and the report issue was that this witness does not have a report. I know that you've objected in the past that there should be a report. If a report winds up being tendered, I will certainly address that on the spot.
Understood. And under your order of Harris versus State, you put in a written order in this case, you said that the experts have to have a report. That's what the Supreme Court said. It's not mandated by the statute, but it's a better course, and we encourage that for our trial.
Yes, and you have made that abundantly clear through the experts that have testified who did not have a report. So I've noted your objection, sir.
And that coupled with no CV until today, Detective Gaither. And that
You have a CV now. You had the opportunity. When did you get it?
today,
What time today did you get it?
or last night,
Are you sure that you didn't get it at some time during discovery?
9:04 this morning.
Was it tendered during discovery at any point in time on behalf of the state?
Oh, I'm sorry, I thought you were talking.
State, was it tendered at,
I cannot say, sir.
tell me what date it was tendered?
And that's what we're trying to see. We're looking right now, Your Honor.
Then-
It is a single page, and it is the document that they do have now.
That's not the point.
I know that I'm looking for what the court has asked me for, and Your Honor, I'm looking at,
It was,
it may have been,
may I make the 2 more points, Judge?
Yes.
As she's thinking, yes.
Just for clarity. And then we are, as opposed to United States versus Ware, which was cited by the state, we are challenging qualifications and reliability and helpfulness. And the reason I say that is because in Ware itself, this may not be an exact quote, but it's very close. Daubert hearings may be helpful in complicated cases involving multiple experts. In the same section.
Multiple experts, but go on. You have to also, multiple scientific experts.
Well, in this case, I have multiple experts, and we're going to have the blending potentially of a fact witness and an expert witness, and you already said we're not doing that. We have to have a demarcation. It's just a lot of information, and I don't know what the expert is going to do that's in addition to and not cumulative of people you've qualified over objection. Detective Dennis, Detective Viverito, or Investigative Viverito, Detective Belknap, who testified, and Detective Underwood. So,
Your Honor.
at some point, to me, you should, respectfully, we should hear, why is it not cumulative? And that's what my objections are. And I appreciate you letting me make the record.
You're welcome, sir. Not a problem. Madam, did you wish to be heard on that last issue, Mr. Steele?
Your Honor, I was just going to say that we've not yet, the jury hasn't heard from anyone except Detective Belknap at this point, and Detective Gaither. We will be clearly demarking and letting the court know at what point we would transition over into anything expert related. My anticipation was today we were not even going to get to that point.
So is the,
Specifically
I'm sorry.
here.
Go ahead.
She is specifically here, in addition to giving her background, what her training and experiences. Of course, she has to introduce herself to the jury, but we specifically are here to.
Now remember, this past week, during these, the jury's been out for the past week, but we've had these evidentiary hearings. There was talk that, they want Detective Dennis to come back. They're calling him back. Whitaker is like, why are you calling him again? And Love still seemed confused. At first, she said she wanted to call him back as a fact witness, but then she referred to things that would really be expert witness testimony. So we had another skerfuffle on the same kind of topic. Witnesses not actually having a Daubert hearing in advance. Love is a little wishy-washy about what question she's going to ask a witness at what point in time. We'll see it as her questioning starts. But just keep in mind that the same thing could be happening with Detective Dennis the second time he takes a stand in the upcoming weeks.
Engage this witness regarding the Dexter Montgomery shooting, that she was one of the ultimate lead investigators on that case. It was turned over to the gang unit, and she worked that case, and we are.
So is she a fact witness?
She is, yeah, she
For
will be
Dexter
both.
Montgomery?
Yeah, she is in fact a fact witness for Dexter Montgomery, and
Dexter Montgomery is the one that was shot. He was missing part of
as an expert.
his
So she's
skull.
not, so at this point in time, she is not,
We will not be eliciting expert testimony from her today. We will not even be tendering her as an expert today.
well, I still need to read the admonition, don't I?
I don't believe so. I think it's at the point where we stop and start getting into the different testimonies. Like when I stop with the fact testimony and get into tendering her, asking the court to have her admitted as an expert. I think the point at which I asked that she be admitted as an expert is the point at which the court rightly give the demarcation admonition, if you will. Because everything that she's going to talk about, at least today, first, will be background and fact. Her background with gangs, just the qualifications, but we will not be tendering her as an expert.
But correct me if I'm wrong, though, but I believe that I did give the admonition before Investigator Belknap testified.
I think Ms. Hilton says that you did, but I'm not certain that I remember the exact circumstances, whether she started with the expert and then went into fact. I think she started with the expert and went into fact. I am going to start with fact, so she's just a regular witness, and until such time that the state asks that she be admitted as an expert, I do not believe it's necessary that the court even broach the subject with the jury. I think.
All right. Okay.
Thank you.
Yes, Mr. Short.
I just want to remind the court of one other issue, just in case it comes up. I brought up the issue last week about, or actually on Monday, I believe, about Investigator Robinson and the issue of an internal affairs investigation. And
Yes, I remember that.
ordered the state, and the state indicated that they may very well go into that, and you ordered the state to hand over all files that would be Brady material and hand them over to the defense. We have not received any of those files yet. So I just wanted to bring that to your attention in case the state starts trying to get into some of those things, that we have not received anything as of yet.
That's with,
Investigator Gaither took over this investigation from that individual, I believe.
So, Your Honor, we would
do we have, well, I said independently, have you found or located the internal affairs?
we had to ask for it. We didn't have it, and I believe that we did request and receive some documents
Okay.
that we will be providing to the defense, but we won't be getting to that person at all at any point today either. So.
It still needs to be turned over. So, Mr. Short, you just remind me again, okay? All right. Anything further?
Just for the informed court, the fair court, we have motions outstanding if it's going to be impeachment for Mr. Walter Murphy. So redaction.
I expect that to be done, and you all should probably work that out. I've seen plenty of conversations about it, but you all need to gather your heads about it in terms of whether or not, because I thought my instructions were pretty clear.
We won't be bringing into any, we won't be bringing any of that before today is up, so I believe that more.
Now, Ms. Love, I'm gonna tell you, before it comes up, you should have redacted that particular, parts that the court has instructed you. If you have difficulties, then that should be put into writing, and I should be able to decide about that. But I believe I ruled upon all of the Murphy statements.
They add more. They add more. That's all there is to it.
Your Honor, there's some additional,
I saw that
some
there.
of it's in conflict with what one of Mr. Turner asked for. And so the state is confused. So Mr. Shard in his motion asked for a particular portion involving Mr. Murphy to be redacted. Now Mr. Steele is asking for it to be in. We took it out. We already did the proper.
Now, this is probably a good point for some context, right? We've heard a lot about Kenneth Copeland. You guys know the 6 defendants in the room by now. But when we hear DK or Walter Murphy, that's the same person. Walter Murphy already did 7 years for his involvement in a shooting where we're going to hear about Dexter Montgomery. This was at a Citgo gas station. He's like missing, it's not pretty. But he did his time for that. And then with this RICO indictment, he pled out, did no time for this. That's why he's able, we might actually watch his testimony again. It happens after Gaither's testimony. I think there's one witness in between. But that's who they're talking about when they say Walter Murphy or DK. Another name you'll hear a lot with Detective Gaither, at least in her first few days of direct examination, is Nard or Demise McMullen. That's also the 2 names, same person. 2 people that are not on trial here with these 6 defendants. And we're going to hear a lot about them through Detective Gaither. And that's because there's this overarching gang conspiracy. But just think about how prejudicial that could be for these 6 co-defendants. We're going to dive into incidents that had nothing to do with them unless we're operating under the theory that everything ever is YSL.
We sent over the redactions as ordered by the court. Mr. Steele, this morning when we talked after he reviewed, had some objections to what has already been redacted. And so we disagree. And so I don't think there's anything except for the court to hear those disagreements, because at this point, we disagree on these additional redactions. But we have done them pursuant to what we've discussed last week, earlier this week. Those are redactions that have been already turned over.
And Your Honor, we don't, like I said, we won't be tendering those if the court will allow us to begin with the witness, and we can, if the court will allow us to further address those matters at the close of the whenever the court sees fit today, I'd ask that the court allow us to do that outside of the jury being here. Because we have been doing the jury meeting. But we won't, yeah, there's no need to, we will not be playing the video today of Walter Murphy. And I believe it's a matter that only the court can reconcile. But I feel that to have us matters addressed every day, leave at 6:30.
Well, Love is asking for longer days because she's behind on issues.
I don't mind how early we need to come in. I'll come in at 8.
Because Glanville's getting pissy about the calendar.
But I feel that to have us not able to properly address the concerns that we have with the redactions that have been demanded puts everyone at a disadvantage when we are notified after we have complied with the court's instructions and after the information was not only served 2 years ago, but 2 weeks ago, there was another notice of precisely the exhibits we intended to use. And the first time we hear about these particular redaction requests is the day we're putting it up. So it's a way that we are hamstrung. We are not allowed to put up our case in a fluid manner. So we would gladly come in as early as we need to and stay as late as we need to.
Just look at Glanville waiting for her to stop talking.
On the record again, like I did at the bench with Mr. Adams a few weeks ago before Mr. Weinstein ever filed his motion, that we be allowed to stay as late as need be and to come as early as need be to address these matters so that our cases aren't impacted negatively by any efforts of people that are different than we are. So I'm asking for that, Your Honor.
I'm going to dismiss the jury for today. Sergeant Ingram, summon our jurors, please.
So, if you did not get to catch much of Glanville's court, if you tuned into this trial late, this is how it went. And Love would say things like that in open court, but then she would be the one running behind, producing what she needs to produce to the defense and causing more delays. So, we do get some more evidentiary rulings. Let's go to the part where they skip the jury out. And that's what I'm saying. There's a lot of days here, but some of them were skipping a lot of time. Some of the streams were only like 3 hours for a whole day.
Chris. Did they include you on Williams' motion number 50? Redaction is out, of course, they include you in that. Did they include you on the email? I'll get you that. If not, what I'll do is, if not, thank you.
His hot mic is crazy.
I mean, number 50, which let me cover a couple of things before we deal with Mr. Steele's motion limiting number 50, which Ms. Weaver's already been included on, and I will include as the next court exhibit in order the email as well as the motion. Here's the problem, as I keep telling you all, and I'm just trying to say this as artfully as I can, but the challenge that we've been having thus far is that while you all are advocates and think that your position is one that you may be able to introduce evidence, if there is a disagreement, I have to take it up. The problem is that this evidence or information has existed in discovery for the longest period of time. And what irritates the court is that I have to keep stopping. It's not personal irritation or otherwise. It's just that I've told you many times before that this jury in the box, we should present and try and minimize disruptions. This afternoon, this morning, was an exercise in disruption. So if you don't want me to exclude your evidence, then the 4-1 judge is a happy judge, means that you file something or you bring it to my attention way before the witness sits on the stand, and I have to kind of go through edits and edits. So to that point, I mean, I can't make it any clearer. And you all are really trying to work yourselves into working on the weekend, because that's the only way I'm gonna be able to get through this stuff, is that I'm gonna have to excuse this jury and we're gonna work on a weekend to get this done. So be it. If that's what it takes, that's what it takes. But I can't keep stopping in front of this jury and taking up things that you all should have forecasted as a problem. What I mean by that, I don't get represents from the state of Georgia. Judge, we're going to go ahead and introduce his PowerPoint or whatever. We have some concerns.
So
We
this
brought
is
them to the defense's
familiar.
issue. And here's the things that we were not able to work out. Because remember, you all are seasoned advocates. This is not your first trial. It's not like you don't know what you think is going to be admissible or not. And if you're uncertain about it, that's why you file a motion in limine. The defense has done so on many occasions. But you all
And we
tried to
recently
kind of
got another
the
motion in
train this,
limine
because
about
if
this,
you don't
this stuff,
present
this
it, then
PowerPoint.
a lot of times they won't know that there's a problem. Or, as I mentioned earlier, the exhibit changes or you add additional things and they don't have the opportunity to take it up. That's why I'm telling you that it's a problematic issue. So that's what I mean by being forewarned. If you don't talk to your opposing side about this, that's where you're going to run into problems. Because I'm just going to start saying, well, if you haven't talked about it, it hasn't been presented to me, and the jury's sitting in the box, I'm going to exclude it. At this point in time, I am very frustrated, to say the least. And I'm just telling you that being forewarned is more than just 10 minutes before we go out, or coming early or staying late. There are some 30 people that have to get in this particular spot in one time. And I can't blame you all, and I won't blame you all, because the law doesn't prevent me to do that, for not being in the proper place and space you're supposed to. And there are a lot of things that happen, because all of us have been, and the court is very sensitive, having been a trial advocate, going from courthouse to courthouse, parking lot to parking lot. I understand what it takes to get in this courthouse in the morning. But you all have to be here a lot earlier, and you need to be sitting in your places. We need to be waiting on them, shouldn't be waiting on you.
He keeps
There
looking
are
at the
least 6 sets of
defense
lawyers that have to get here.
every
And you all should
time.
not be just sitting down when I get here. If I tell you to be here at a particular time, please be here and be in place so that I can go ahead and start. Because we eat up time that way. And I mean, I just don't know what else to tell you all. But I'm trying to be as patient as I can. But I'm at a loss for words at this point in time, because I have said this over and over and over again. So if you don't want to see contempt, if you don't want to see us working on the weekends, then please change what you're doing. And Mr. Starr, the inquiry I made this morning is a valid inquiry. None of you would do this if you were in the United States District Court. None of you. My colleagues in federal court would probably jail most of you. And for those of you that have practiced in federal court,
Foreshadow.
this is not the way it goes. From the state's perspective, as well as the defense perspective, everything's filed in advance. So why should you do anything less than in this courtroom? I don't see the same level of professionalism and attentiveness that you all need to do in terms of getting issues fleshed out. It's last minute. That's not fair to anybody. I got a rule on it. I really want to get it right for everyone. I'm the gatekeeper. I have no interest in case other than see.
Has anyone seen him look over to the state's side of the courtroom? Because remember, the state from where Glanville's sitting he'd be looking over Kristen Weaver's head towards us on the screen, like towards the camera pool. Has anyone seen him in this whole diatribe look over in that direction while he's cranky about timeliness and causing delays at all? Has anyone noticed that? Put a 0 in the chat if you have not noticed it. Put a 1 in the chat if you have. And then Steph JK, thanks so much for the super chat. Not only do we have hundreds of witnesses, but we repeat witnesses on top of it. And a judge that missed so much. I'm tired. Oh, and that's the thing. So we heard Judge Whitaker express concern about why we're calling Detective Dennis back. What do we need him for that he didn't already testify to? Can we make sure we're not just playing the trial that way? And then when that conversation came up, the defense pointed out, well, they still plan to call other gang experts. And these gang experts are all trained at the same precinct. They have the same foundational training. So what can one of them provide expertise on that another cannot or did not already do? So this isn't going to be the end of it by any means. But thank you, Steph JK.
He's fairly tried, but things have got to change. That's why I asked that to you, Mr. Sharp, this morning. It wasn't for any other reason, because some of this stuff I'm just at a loss for. You all are seasoned advocates. It should not make a difference whether or not somebody brought it up or who said what. If you know it's going to be an issue, flag it, present it, and let me deal with it, or let me carve out a day so I can go ahead and deal with it. I can't deal with this as a witness on the stand. That's not right. So that's why I asked you that this morning. So in the interest of trying to kind of get the right, please just modify your habits in terms of stop this last minute stuff.
He looked over when he said that. He said.
Looking at motion in limine number 50, the redaction. All right, Mr. Steele, I have it. I marked it as the next court exhibit in order. So let's talk about it. So in paragraph number 1, you were saying this is the statements that were made on August 18th by Mr. Murphy?
Correct.
And you're saying it doesn't comply with my prior court order that all statements made by non-witnesses
Right.
be redacted. So those were supposed to be redacted. All right, there's discussion you indicate regarding unrelated crimes that are not redacted.
That's true too.
So, and then the state redacted the exculpatory Brady evidence that Mr. Copeland, not a co-indictee, killed Mr. Thomas, and this is not speculation if it's co-conspirator hearsay. So let's just break that down. What about the unrelated crimes issue?
Your Honor, there is a conversation about other armed robberies. I'm looking for the exact time that I can point you to. It's on the redacted version that we received this morning from the state. It should be at 11 minutes. It starts at 11 minutes. And again, it's Jacoby Hudson speaking. They talk about sex crimes, and then they talk about who shot somebody in the hip. Going to get life in prison. They carjacked a federal agent. He has so many charges. Jacoby Hudson, the lawyer, asked if they're prosecuting that case.
Okay, so
And to me,
that's from 11 to about 13:56, right?
yeah. That's
Okay. Is the state seeking to introduce any of that?
Your Honor, the state asked the court, here's the information before we make our argument. I asked the court, that's not my microphone. We asked the court to be allowed to play the segment that we have just been.
What's the basis for its admission? Why do I need to hear it? I can read it and say, I can read it and tell you it probably doesn't have anything to do with what we're covering.
Well, Your Honor, the court and counsel are aware, our rules of evidence favor inclusion, and this is not inadmissible. There's nothing inadmissible about these portions that were brought to our attention, or else we would have flagged them. We actually agreed to take out things that were not permissible.
It's not relevant. It's not relevant. How is somebody about this conversation relevant for anything? What does the carjacking of a federal agent have anything to do with it?
Your Honor, as the court recalls, when we last time excluded a chunk of information and attempted to play portions that became relevant when a witness did not understand, we were denied the opportunity to do so. That is why we are asking that the court not whole hog grant chunks of information be excluded without hearing the chunks of information and allowing the state the opportunity to point out the portions where we disagree.
We're not going through what we went through this morning, Ms. Love. I'm sorry. I am sorry. We're not doing that. I excluded that because look, I had made my ruling on that particular issue. So I'm not going back and talking about that.
Your Honor, I have a question for the court, because I think the state.
I already ruled that we were going to exclude that particular portion. I ruled on it because we had argument on it. So
Yes, sir, yes. So, Your Honor, the state just wants some guidance from the court. And the reason why we're asking for this guidance, Your Honor, is we have your administrative order that was filed. And what the state did, especially when we speak specifically
Hilton
about
needed to
Montgomery,
assist with the
on
argument.
April 4th, as the court instructed, we turned over all of our evidence to defense counsel that we were going to use, everything. That included all these recordings that we're talking about right now, that included what you excluded, the portion that you excluded earlier. We turned that over on April 4th. We received one motion in limine about redactions. That was what Mr. Shard filed on behalf of Mr. Stillwell on April 10th. Then we got another one this morning on April 17th. So what the court asked of the state to do, we did in order to avoid any late arguments. What we understood from the court's administrative order is that state turn over the evidence so that defense counsel can review it. If there are any objections, they would file such. They did that for a portion of it. They never mentioned Mr. White's statement in this motion. They never mentioned any of the other redactions that are coming today.
I got it.
So
But let me ask you a question. Are those particular portions admissible?
which portion? For talking about Mr. White or for what we're talking, what Mr.
What we're talking about right now.
We have to go look at the earlier portion. What we have in the earlier portion of this statement, I believe it's the August 18th statement that we're referencing, is that in the room is Mr. Hudson, Investigator Dennis, and Mr. Murphy, and they're talking prior to the interview starting. Some things are relevant, some things are not. We need to look at it and decide.
But that's what you should have done already.
But we just got the information, Your Honor. We didn't know.
All right.
So the state believes that it should all come in. So if the defense has an objection,
Okay.
then they have to let us know so we can talk about it. And we actually had some conversation this morning before we came to court to see what we can resolve. So we're trying to follow the court's instruction.
I know that, but,
So-
but I want you to go further. I want you to go further in the sense of you need to review your evidence before then and realistically kind of look at this in terms of whether or not it's going to be admissible.
But Your Honor,
because
they never-
it's not like, that's what I'm talking to you about.
But Your Honor, they already filed a motion regarding this particular interview, and it didn't flag it, Your Honor. So the state is on notice about what they already.
I understand that,
And
but-
they literally list out August 18th, 2015. And then I think even Mr. Harvey had an additional redaction that we added to it. So we are following clearly what the court has asked. So this is what they objected to. This is what it is. If there was any objection earlier, they would have said that. So we would have been able to argue it a week ago when we argued
Hilton's
this much.
snapping.
So this is not a new interview. This is not old. This is the same August 18th, 2015.
It's the same, I know, but
So
Mr.
they never
but Mr.
notified us. And Mr. Steele is really good at notifying the state about objections. He did not. And so we didn't think it was an issue until he
understand.
brought it to our attention.
I understand.
And we talked to him about it. We did not agree. And I think that is why Mr. Sharp brought it to the court's attention this morning about Mr. White, because we did try to
Post-it
resolve
is flying on
And I
the
think he
floor.
brought
You
to the
see
court's
it
attention
over
because
here?
We could not resolve it, and we wanted the
It's
court to
a-
make a ruling. And we were trying to find the time that the court was going to make the ruling in order for it to happen, because we were following the instructions based on the administrative order. The order said, turn it over. We turned it over. They are going to launch whatever objections we have. If we can agree, we agree. If we can't, we bring it to the court's attention. I think that's what's been
All right,
happening.
so this 11 to 1356, do you have it queued up at this point?
104.
I understand what you're saying, Ms. Hilton. You're saying that two defense counsels have differing opinions as to what should be redacted or included.
That's a different portion. That's not even this portion right here. That's later on. And we redacted based on this what now another defense counsel wants in. But again, we were not put on notice so we can have that argument and hash that out. So we're trying to follow the court's instruction. We want to move this case along, and we're not trying to prolong it. But there are going to be times where the state and the defense are going to disagree, and we just want to make sure that we are properly following the court's instruction. And that's what we want to make sure. And so we just want guidance from the court.
Try not to, okay, I understand that, Ms. Hilton. Just try not to do that like hours before I need to come, because that should not be what I'm feeling right now, that's more the rule than the exception. And I don't want to do, and the court doesn't want to do that anymore.
So if this, so what I'm asking is, if we disagree, if we talk about it and we disagree, should we then notify the court that we discussed it and we still disagree and we think there needs to be a motion? I mean, we need to have a hearing, excuse me. So I just want to make sure that the court, before coming to court, is fully aware. We talked about it, we disagree, we may need a hearing so that the court is aware. So I just want to make sure we're following.
The earlier the better, because then I decide whether or not the jury comes in that morning, how long we need to do it. Do we need to work the weekend? What time do we need to come and deal with it? But the more in advance I get a chance to look at it, like I said,
And I believe that Ms. Love.
but this is not the way to do it. This is not the way to do it.
And I think we tried to make calls earlier this week to defense counsel. Those calls may not have been returned, but I know that Mr. Sharp was dealing with some things as well. So there could have been a variety of reasons why those calls were not returned, but we were making calls as well to get this resolved in advance. So we want the court to be fully aware. We're not trying to wait till the last minute. Trust me, we are not trying to delay anymore. We want to get this case moving along, but we want to make sure that we're following the court's instructions and not have evidence excluded after following the court's instructions.
Now this is crazy too, because Hilton was snapping there too. It wasn't just Love this time. Like at first it seemed like she got up there. I thought she was getting up there just to get Love to sit down a little bit. She could make the argument more clearly. But she's like bullying Judge Glanville into ruling a certain way. Like, and I'm just thinking about how this week, it was Thursday. It was the last day of court. Judge Whitaker got mad because Bruce Harvey started like yelling in court because of something Love said, an assertion that Love made that likely wasn't true. And Judge Whitaker cut that out. Was like, no, we're not going to do this. And not only did Glanville let Love get away with it all the time, but there's Hilton doing it too. But yeah, so thank you, Black Butterfly. Notice how Love doesn't bark at Whitaker like that. And I know because of this super chat, I did a poll. Answer the poll or talk about it in the chat. Do you think there will come a point where Love does what she has done with Glanville with Judge Whitaker, with the new judge? Or do you think she'll, schoolgirl it the rest of the trial? Because I'm curious to see. We have not had cross-examination with, and Hilton really should be raising the objections during cross of Woody, but who knows? These lawyers seem to tag team. These prosecutors seem to tag team more than I've ever seen in a trial. But we haven't had cross-examination of any witness since Judge Whitaker has been sitting at the bench. So I think we're going to have some opportunities where Love's going to try to keep objecting to things that she doesn't want the defense to be able to ask a witness. And she might lose her cool if Judge Whitaker makes fair rulings that don't consistently lean in favor of the state. So answer that poll. It was inspired by Black Butterfly. Super chat here. Thank you so much, Black Butterfly. And Steph JK says, imagine the state giving Judge Whitaker this attitude. Never. Never. They have been very, very calm, polite, giggly. There's even times where Love has giggled along, like kind of amping up jokes, in my opinion, sometimes. That's the way I look at it. When Whitaker giggles, sometimes Love will be like, haha, yeah. So very chummy. Chummy, chummy, chummy. But who knows? It could switch. It could switch as soon as they don't like the defense being in charge of questioning a witness. So we will have to see. Thank you so much, Steph. And then Patrick Taylor, shout out for the $4.99 super chat. Trucking with Kat, New York to North Carolina. Love it. Well, where are you stopping for food along the way? Drive safely. I actually, depending on what route you're taking, I've done that drive a few times, and as long as traffic isn't bad through any of the major cities, it's not a bad drive. So glad you're here with us. Thank you so much. And let's get Hilton back to her seat.
Do you have a flag, madam?
We're pulling it up. It has to play an evidence reviewer, Your Honor.
Mr. Steele?
Just want, everybody should always be nothing but honest with each other in every dealing and professional. And I think that members of the state have done that and will continue to do that. And I know that the defense is trying to do that all the time. But I do want to raise one thing. When I received this today, the redaction today, that's what I filed, motion limiting number 50. You already ruled on motion limiting number 47, which I filed on 4/9/24. And I specifically wrote in paragraph 2 that the state has indicated it will potentially use interviews and proffers of Mr. Walter Murphy, which is what we're talking about, as exhibits at trial in the above referenced case. Then I wrote, Mr. Williams respectfully requests that, I wrote, without Attorney Hudson, becoming a witness in this case, Mr. Williams respectfully requests that these portions and any other similar portions where non-testifying third parties make statements on the recording be redacted. This includes, I also wrote, any jail calls. The admission of any non-testifying third party at a proper setting or meetings with the police violates Mr. Williams' constitutional rights and Confrontation Clause as well as inadmissible hearsay declaration. You granted the state today, and I'm not casting aspersions. When they gave the redaction, I was surprised because all this that I have in there, except for the Brady and except for the Mr. Copeland shot the man, it's Mr. Hudson. You've already ruled it out. So for the state to say it, I'm not saying they're saying it wrong. Maybe they forgot you ruled. But those are all the issues. Mr. Hudson and Detective Dennis, I know you haven't seen it. I guess a friend. They get into a major discussion throughout this interview. That's what I flagged. So I wasted my time today to do what you already ordered because you want to have it in writing. And, I'm trying.
I understand it. And
that's it. And that's all that there is. So for the state to say they got it today or, there's conflicting, it's not conflicting. Mr. Sharp, Mr. Harvey had issues. I had these
yeah,
issues.
I did rule upon that earlier, State. So, in terms of statements involving Mr. Hudson. So,
Your Honor, I think the court should, I'd ask that the court respectfully look back. We carefully, Ms. Hilton was here that day. I was not, I believe. And Your Honor, the court, Ms. Hilton took diligent notes about what was to be excluded. I believe that the resolution to what we disagree on would be sought in what the court said on the record. We took out the portions that the court ordered that we take out. Respectfully, Your Honor, I'm certain that there are areas where people can disagree, but I do know that we have been working very diligently to get those redactions done at her urging, as she was the one here listening to the court. So I'm not certain if there was a miscommunication, if one lawyer heard one thing and another heard something different. Perhaps the answer lies in the record itself. But we took out the portions we were ordered to take out. And as it relates to other matters, Judge, we do not have an agreement. We cannot agree on what the court said that we should recognize things that might be a problem. We did, and we don't disagree on those. But the portions that are absolutely not impermissible, Your Honor, and that are only brought to us as a problem, the night before the witnesses to take the stand, we cannot read minds. They're entitled to argue about anything, but we have tried, and many times more Ms. Hilton than I, but we have seriously tried to be extremely accommodating and to anticipate problems. But when we firmly disagree as to whether
Look at Weaver's face,
are
the court reporter.
relevant, not relevant, that's the place where we have to come to Your Honor. And respectfully, Your Honor, that's what happened today. We were blindsided, and with the way that if the defense counsel is allowed simply to make an objection, and we didn't come up with whatever thing they found in some way could be possibly in another universe inadmissible, then the court has told the state that the court will exclude the state's evidence because they came up at 9:46 p.m. the night before after having this stuff for 2 weeks. And after hearing cross-examination of D'Angelo White, Your Honor, where Mr. Atkins specifically confronted Mr. White with the very statements they are now asking not to be included. The very statements. He literally verbatim asked Mr. White, over no objection for either of the defense, these exact statements. And now they want to keep them out because then it looks like he was arguing something or assuming facts not in evidence, when in fact, he was simply confronting the witness with a prior inconsistent statement, as he was supposed to do. So at 9:46, we did a motion in limine to exclude it, and they've had this for 2 weeks knowing who were going to do exactly that. After Mr. White took the stand, they knew we were going to do exactly this. So we literally have been talking to them. I've called and said, talk to me, call me. Here, I've been told on the record, we don't want to talk to her. Literally, that's what was said on the record. We don't need to talk to her. And so, Your Honor, I'm begging the court not to hamstring the state and leave in the...
I'm not trying to hamstring you, madam, but I want you all to be prepared.
We
It's
are,
ridiculous.
and we have been, and we literally told them last night, we are sending over this final redaction.
But I do
And
not.
then we get this whole list of things. I mean, it's disruptive. You know, we get it at 9:46 at night. And it's not fair to anybody, frankly. The defense, the state, the jurors, the court, it's not fair to anybody.
Well, stop doing it then. I mean, that's the thing. Stop doing it.
And we have anticipated a lot, but the things to anticipate, to anticipate, Your Honor, not.
madam,
Yes, Your Honor.
I'm kind of just, I'm tired, okay? I really am. I really am. Mr. Sharp?
I'm gonna try not to belittle the point, but we at this point we have filed motions, and I have been filing motions the day before, and Your Honor has said certain things to me, and I accept that, and I'm not complaining to the court, but the things that I filed in those motions are legal arguments that I never thought I would have to make because I did not think the state would ever try to admit such evidence. Because we have all gone to law school, we all know what hearsay is, we all know what inadmissible evidence is, we all know what irrelevant evidence is, we all know that we wouldn't play recordings that talk about unrelated crimes, wholly unrelated crimes. We all know that we wouldn't play recordings where people say what other people said. So that's, respectfully, Your Honor, and maybe I haven't articulated, that's why I haven't filed these motions. But when I see the state put in their anticipated evidence coming forward through Investigator Dennis, a PowerPoint presentation that is just full of hearsay and full of incomplete, irrelevant, extraneous information, then I actually was put on notice at that time. I said, the state really thinks there's no rules to this. So I really need to start flagging everything. I was not trying to be disrespectful to the court by waiting to the last minute. I didn't think it was necessary to say, I want the state to follow the rules of evidence in the presentation of this case. I am now on notice, and I will be flagging everything I can think of and try to have a happy judge because you will be a forewarned judge. But I want you to understand that that's where I'm coming from.
I understand.
And so a lot of these things, I just didn't think we'd need to argue about.
All right. Let me hear the statement, the audio from 11 to 13:56.
Hey, old school, yeah. What's up? Now, don't my favorite investigator. We was at prosecution. We was knocking back. I heard you the whole time now. You want to see way? 6 times.
I know people. I think you said 100. How many?
You talking about David? You know David?
Okay, right in the door with me, bro.
He done. How much he done it on?
For the TV, for the officer.
Yeah, you want to know what? Because he gonna be a fool. What?
That he doesn't like being tall skin.
No, he probably about the other place. He like, he ain't like, come on, my phone, too. Yeah, it's not like he just like this. I'm in my girl.
You got those guys. You slim, skinny, tall.
Yeah, you got shot in the hip by the homo. Yeah.
That's what they said too in the bone.
Gee, you gonna get my life. They call Jack the Federal. Yeah, I heard that.
But you do have 100 and something charges, bro.
Murder, 3 home invasions.
Man, they.
5 years on that. You good? Okay.
So they just.
You gotta call it.
So they just. When you just waiting on every day doing shit. But you get out in one day?
No. Appreciate how you was playing Grand Theft Auto in real life. They what? Dude. Oh, they on camera.
See, he shot, bro. He shot.
Appreciate you, my guy.
No. You got a little boy going.
For real, honestly, they just got over. They went over. Like, they was not taking it serious. They ain't like prosecuting that, though, is he prosecuting? I'm serious.
Who's Dave?
They had a game for him. He damn sure like couldn't play games. You heard? I told him, I said, oh, damn, what they say? Hey, we folks ain't really. Shit, the real, you know, me, Gaither, Lance. You old school. You know what's happening. Gotta know. Y'all want to see, I did. Yeah. Lance Cross? Knew that folk ain't got no goddamn trying to everybody. Everybody leave. Everybody on what you on. But shit, they do one thing. We trying to, like, I don't know if you admit, AJ and Michael Lord. Michael cool as hell, man. I know Mike. Don't give him no chance. Man, damn, I move up. Like, the real, he, like, I'm still doing, like, petty drug cases. In the building. Yeah, but then, Jay was, like, having me doing it. You know, I did all the free lives. I was signing off on 10 races. Everything. Shit, I spoke the language.
Hey, you want to ask someone investigating that other time?
Tell me what we talk about. I told you, you need to think about play. So if that means that you can see your song, you need to talk to them folks. All right? I told them, yeah? All right? So.
Yeah, I've been getting right up in the cup. I don't know if you got it. I think you got it. I think 2 niggas got shot. It's go high.
Just hang on. Hold on. Girl, I told you. We get that person in here who handles that thing. Question though, these folks don't get the chance to see that though. Don't try to keep this right. Yeah. Like, I don't want nobody, like, no general, like, seeing that. That Wallace Murphy out here telling me, no, they ain't gonna. I know. This is like this. And this, On the record, off the record, first. I grew up in the streets. She grew up in the streets. She from Southside Chicago. I'm from the West Side neighborhood. I know how the street. I know how the street go. We not the ones that will put your business out there. If you're out pillow talking with people in the cell with you, your girl, the one cat that you think is your homie, y'all tell it. You wanna know what happened? When you come in, no. Listen. You don't have to let it go. Once y'all get on the phone or once we'll put your business out.
And so, Your Honor, up until the point.
What time did it stop?
This is not the point that we were talking about. We played it beyond the point that.
Yeah, I know that. So what, you started at 1100. Where'd you play to? I think you played till.
They never know. When Atkins isn't bad at it. When Atkins is steering the ship with playing videos, stopping and starting, he's been all right. But otherwise, they're always, oh, sorry, we meant to stop, but we played longer than we were supposed to. Oh, sorry, we were supposed to stop there, but we went a little longer than we were supposed to. Like, you can't just be doing that, and you can't just keep doing that over and over and over. Like, but whatever. Whatever, love. Just, I guess, do whatever you want, because it's your show. And Black Butterfly says, the PowerPoint? Yeah, so we're gonna see, and we'll leave that part. If you guys watched, I did a throwback to a certain part that's coming up a few days ago. But we're gonna watch it on faster speed to see it really spit fire. It's gonna be a good time. But yeah, that same PowerPoint that Judge Whittaker considered. She dismantled it to the point where Love said, all right, we're just not gonna use it. We'll do it pictures by picture if we didn't already admit a picture. But she still considered it. Whittaker still considered it, even after Judge Glanville excluded it. We're going to see that whole thing coming up.
Till almost 1600, something like that?
We played till it looks to be 1607.
Okay.
And Judge, the point up until where you hear Mr. Your Honor, the court indulgence for a moment.
Yes, ma'am.
Your Honor, I apologize to the court if the court will not move.
Yes, ma'am.
Or actually, the clip I'm thinking about wasn't today. I don't think. Maybe it was, because I swear they were wearing these outfits. I swear that was the outfit. Unless it was earlier. I think it was earlier in the day. We'll go back and watch it. When this day's over, we'll go find it. I swear it was this day. Okay, I can't hear this call at all, so we can skip this if you guys want. We'll just see what they argue about it.
Mr. Hudson, did employer say?
What is this section you're playing me now? Because I wanted to hear 11 through 1356. I heard it already.
So they did it again.
What was it you were going to tell? Because I heard that. I heard through 1607.
Okay.
That's what you told me.
So the part that we were saying we had no problem up to was the point, and we were trying to find the timestamp where he said, I told you, Mr. Hudson is imploring Mr. Murphy to think about his son. And that if that means he can see his son and talk to them folks, all right? So when Mr. Hudson is encouraging Mr. Murphy to be candid, that portion, up until that portion, we have no problem with. But given the cross-examination and the questions that have been asked and the answers that were given on the stand, we believe it is very important that the jury hears, because Mr. Murphy said many times, as the court's aware, He would have done anything. Well, the jury should hear what Mr. Murphy heard and how, what his reaction was, because that's what we're asking for it to be admitted for, what the effect of the words of the people around him had on Mr. Murphy, because the argument has been made already and will be made throughout this case. Mr. Sharp's whole opening was about doing something or another, Fulton County. And so the argument is being made that people are attempting to lie their way out of having to spend more time in jail. When you have a piece of evidence where a person whom a witness trusts is not threatening him, and no one in the room is threatening him, but he is being provided a nurturing kind of environment and being encouraged to just be honest and think about his children, the state believes that it is a very important part of this witness's prior inconsistent statement that the jury should hear. The jury should hear the effect of Mr. Hudson's words on his client at that moment. We have both detectives in the room. It's not a hearsay issue. We're not offering Mr. Hudson's statement for the truth of the matter asserted. We're offering them for their effect on Mr. Murphy, who has now come in and said something way different than what he said during his interviews. So, Your Honor, up until this point right here, up until the point where he says where Mr. Hudson tells Mr. Murphy, you need to think about Blake, the state has no problem with it because it doesn't deal with him and this negotiation that he is engaging in. They're just having small talk. We are perfectly amenable to taking out up until that point, and we will get that correct timestamp for the court and make certain that we have that to the court. I don't want to play it again because everyone is tired, but I would like for the court to at least understand that we are not asking to include everything that they want out. We are just saying that relevant portions, and of course, number one, the bar for relevancy is low. But number two, we're not trying to get in hearsay. This is things that were told.
Okay, but what is it? Okay, assuming Mr. Steele's time hacks are correct, at 1100 hours, 1100. Somebody stops by and says hello. Hudson knows and speaks about sex crimes till about 11:15, about the first 15 seconds. All right. So, what does that have anything to do with this case?
If that's at the very beginning, I don't mind that being out, but we can't. The problem with giving a generalized description of something that's being said is that we could end up having excluded important parts that we don't agree to and that are relevant and not inadmissible. So that's why we are asking the court not to rely on generalized description of a segment of a witness's interview.
Do you have a transcript of this particular hearing? I mean,
yes, we haven't had time to correct it, but we do have a transcript and we're looking at it and we can provide it to everybody.
The same transcript. This is like deja vu number 5. Let's say the counter's at 5.
We have not had an opportunity to make sure that it's an accurate reflection of all that is said, but people said it anyway.
Let me ask y'all. Well,
Yeah, I do have the
needs to be corrected,
timestamps
but,
ready to lock and load to go to the PowerPoint argument from this day as soon as it's
Well, here's
done.
the challenge. Challenge is that you need to, or it seems like you need to have a transcription of the tape so you can kind of figure out, well, what was said so that you can get the exact time marks. So, an agreement.
We agree with that.
And you don't have that. That hasn't been sent out.
We have it now. There were issues. We ordered it months ago. We were frozen out. So.
Can we take up some other witnesses or hear some other testimony while that is being done?
Well, it's already been done. Put you in the transcript.
Yes, because the transcript, I mean, because it seems like to me, I'm not going to be able to kind of rule upon this until you all have the exact time, or what is said, so you all can kind of say, okay, listen, we want to chop out from here to here, we agree, here to here, we don't, and I can kind of then look at it from that perspective.
Your Honor, if I may request something on the court, since we have had an opportunity to check for corrections, but since we have a transcript that we can provide to the court and to counsel for the defendants, will the court require the parties to identify the portions, the segments, with the appropriate times that they come up, the specific lines in this 161-page transcript that they are asking to be taken out. Since they have already time-backed it, they should be easily able to find the portions in the transcript, even if the words are not always exactly correct, and at least give the state, some hours, so at least by 10 o'clock tonight, provide to us what specific portions they want.
My suggestion is you take that transcript and the two of you, that both sides sit in here and you figure out.
What if I don't know why my brain went there, but I was like, well, my suggestion is you take that transcript and you shove it. I don't know why I thought he was going to go there. Like, obviously he wasn't going to do that, but my brain.
Exactly what you want to line out and what needs to be, what I need to rule upon. Because it sounds like you probably have some things that will probably be not in disagreement. There'll be a limited universe of stuff I got to kind of consider, but this is not fruitful. This is not a fruitful exercise. It's just not.
So, Your Honor, what we can do, we'll do exactly as the court directs.
Well, that's my suggestion. I mean, because
when we're asking that the court allow us to report a little bit earlier than the court had originally planned, so that if we don't hash it out right now, we can have the court make that decision before the jury even ever gets in the building. And Your Honor, what I can do is, for the sake of moving things along, I can play portions beyond anything that we can't agree on. I can play portions of it with the understanding that after the court makes a decision, we are.
With the understanding that I'm going to keep playing it longer than I'm supposed to.
But this is something that can be dealt with between now and the time that our first witness is to report tomorrow. This is one interview that will not stop the show. We can do what we need to do, and we can say, and we can go over this, and we can report as early as the court asks us to. And we can send a report of our ability to work through it to the court this evening. So the court is on notice as to what we were able to agree on and not. We may come up with a solution that's acceptable for everybody. I don't know, but we're willing to stay until it's done.
Mr. Sharp, I saw you rise.
Your Honor, two things. We have already identified those portions, but the other larger issue that
I don't think you've identified them with they don't match. I mean, because theoretically, what you have and what Mr. Steele has and what the state has should all be in the same. Like the first one I heard, I didn't hear all the words. The second one I heard all the words.
But the larger issue, Your Honor, and I'm just speaking from my experience, generally when we've been dealing with prior inconsistent statements, in my experience, it hasn't been someone said something that the state feels is inconsistent, so they just put in a tape. It's focused. If Walter Murphy said the sky was blue, and then on the stand he said it was red, but he said it was blue to Investigator Gaither.
This is so funny because of the Woody example.
On January 1st, 2023, didn't he say the sky was blue? And then that's how they get in the prior inconsistent statement. I don't really understand why we're playing just these lengthy tapes to impeach people, because it's not focused on the inconsistent statements. And that's why we're getting in Jacoby Hudson giving, friend talk between Jacoby Hudson and Investigator Dennis and all these other extraneous things, because we're not focusing on the discrepancies. And to me, that's what prior inconsistent.
Okay, that's one thing, but the state says that the effect on listeners. So what's your take on that?
That is irrelevant. That is not proper to be playing tapes of Jacoby Hudson, who's a witness in this case,
Well, he's
speaking.
not a witness. He's not.
Yeah, he's not a witness. That's what I'm saying. He's not a witness. And so I don't know why we would be playing tapes of him talking to anyone.
For context, Your Honor. And we also.
Shout out to
I
Nick
understand that the state wants to,
Starro.
but
We confronted.
I thought you'd be on a plane already. Oh, so you still have a
His
long
lawyer-
trip to
His
go.
lawyer statements, Mr. Hudson's statements aren't relevant.
You're going to be on a plane for as long as Love argues this spiel. Thank you so much, Nick.
Did they tell you that you could?
I hope you have the safest
Did they tell you
and
that somehow-
somewhat entertaining
Okay,
flight,
so
as
they
entertaining as it can be.
said, and they were not allowed to meet that with what he was told by his attorney in the presence of others, so it's not protected or privileged. It is absolutely relevant, Your Honor. It's not,
Oh my God, listen to her.
I get that, but it's very defined and targeted. Him talking, Mr. Hudson talking about, these sex crimes or shooting or whoever. That's not relevant. That's not relevant.
And the court said exactly right. There are portions that we actually don't have a problem with excluding. We agree with ground, okay, we'll take it out. But the portions, and that's why we need to go over, because the portions that we believe should not come out are the portions like that, where as opposed to, as the defense has intimated throughout this trial, people are being forced into taking agreements that they don't like. And the words of the prosecutors are somehow being made at issue. When a person is being encouraged to be honest, and they have every motivation to, Mr. Murphy got up here in front of this jury and he just decided he was going to imply that he lied all the way throughout all his interviews. It is very important that the jury understand what circumstances Mr. Murphy made these statements under, and who was doing what, if he was being threatened with jail time unless he talked, because that's the image that they're getting. And they are asking the court to exclude the state's relevant portions of these interviews with Mr. Murphy and detectives in this case with his trusted friend. If the court remembers, on cross, Mr. Murphy was asked about his relationship with his lawyer. And on cross, he was asked about whether or not Mr. Hudson paid his bond. So if they're going to be able to bring up things like whether Mr. Hudson paid his bond and how close Mr. Hudson was to Mr. Murphy, then the state should be allowed to introduce portions where Mr. Hudson is encouraging Mr. Murphy to just be honest. And he is.
I don't have an issue with that specific, but these other conversations, and then talking about other crimes, about improper statements about other people,
Those are before that.
but they need to be excised. They're not relevant. They're not relevant.
Okay, so just so we clarify.
Everything up to that point.
She's clapping. Oh my God. So I just put it down to one speed, normal speed, so you can hear that she still sounds upset, even on regular speed. It's not just that we're playing it faster that's making her sound that way. She is upset. She is raising her voice. And now, coincidentally, she's clapping her hands to help make her argument here. And thank you so much again, Nick Starro. And I think it's always so cool that you use American time zones for us so we can understand what time zone you're referring to. That's so nice of you. It's so considerate. Nick, you have to be like one of the most considerate people I know that I've met through this trial. It's such a delight, and then now I gotta play Love.
But they need to be excised. They're not relevant. They're not relevant.
We agreed to take out everything up to that point. That's what we're saying. This is not something that's, this isn't even the hard one. We agreed to take out everything up to think about Blake. And if there are portions after that they feel strongly about and they want us to reconsider and look at, then allow us the opportunity to do that. But they're not wanting to do that. They're trying to argue the issue about whether or not the recording is even permissibly played before the jury. And that's just an effort to try and get the court, I guess, to wear the court down and have it all taken out. But Your Honor, we're just trying to get in. We're trying to talk. We've been doing it all along. We're not going to stop. We're trying to come to some agreement as to what can be done.
All right.
Judge just took a deep
Mr.
sigh.
Adams.
Let me just say this. Along the lines of wearing the court down and trying to confuse the court, let's be absolutely clear.
Wearing the court down and trying to confuse the court.
She doesn't appear to really know. Is that it was Ms. Hilton who asked the witness about his relationship with Jacoby Hudson. It was Ms. Hilton who asked whether or not did he pay your bond. Now, nothing in what Mr. Murphy said. He never said, I said what I said, or I did what I did, or I gave this statement because of something that Jacoby Hudson said to me. So just because they want to try and infer that that was part of it, doesn't mean their strategy becomes evidence. There's nothing relevant about what Mr. Hudson's saying to Mr. Murphy. It doesn't become relevant simply because they want to use it. And if Mr. Murphy in his testimony had said, you know what, I would have done anything to get out of jail, or what my lawyer said to me, had some effect on me, then yeah, they can impeach him with that. But he never said that. And can I finish, please?
Hold on. Let me finish.
Any question about his relationship with Mr. Hudson and how close they are came not from us. It came from them.
Okay, so Your Honor, he literally said that. I would chop out my arm. He said
He did. He said that.
He said it throughout. Every chance we asked him a question, every time we asked him about this interview, and Ms. Hilton confronted him with the states, I don't remember what I said, but I was high every day for a whole year, and I would say anything. I would say and done anything to get out of here. I would say and done anything. So throughout.
Okay, hold on. What if somebody clipped her saying that, reposted it to Instagram, and then someone wanted to say, oh, look, there's this Instagram post where Love is saying, I was high every day. And she posted it on, 8/22 while she was in court. She's high in court. This Instagram repost says it. Like, what if someone soundbited her doing that and then reposted it and tried to use this evidence against her in a case? And the judge just let it in because who cares about foundation? Like, it just seems so crazy to think about. Like these little sound bites when she's quoting people. Someone could just clip her saying that and then try to use the same strategy to say she's the one that said it. Or interpret how it was meant literally.
His testimony on the record, he kept putting forward that he didn't remember and wasn't truthful and had reasons to not be truthful, and his impetus to not be truthful was he wanted to get out of jail. The one thing that is true and obvious from this recording is that the only thing he was asked to do was to be truthful, even by his trusted friend. He was asked to be truthful. That's it. So if he had any.
Okay, but that's only a couple of statements from Mr. Hudson, which I agree with Mr. Adams may be marginally relevant in terms of what was said, but I think that he's already been kind of examined on that issue. So
but he never told the truth about it. He continued to be untrue.
But that's what the jury's going to decide. The jury is going to decide that particular issue. But I'm telling you, you get into more problems. The ADA
is probably like
this particular state. You just do.
And we have to give them the right to say to make the decision. Otherwise, all they heard is him saying, "I don't remember." And I was told anything to cut off.
Okay, but I understand that, and that's a disagreement, that you and Mr. Adams have and Ms. Hilton has. But all this other stuff, not relevant. It's not. The conversations with Mr. Hudson are not relevant. They're not. So I mean. And this transcript's 100. I mean.
The portions that they're asking to be taken out, I believe, in on page.
What page?
I believe it is on page 30, I think. I'll have to listen to the general time to be sure that I think
The page 30 of 161, the interview of Walter Murphy?
Yes, I think that.
The August 18th, 2015 interview?
Yes, I think that's what they're asking for, up to the point where Investigative Gaither says where. So I think the last part where conversation is taking place is Mr. Hudson saying, I got referred to him because his mom and his grandma went to the church praying folks, and I've been mentoring kids there for about 2 years trying to get them right, but I can't keep them away from you all. And then Investigative Gaither tells Mr. Murphy, you're gonna have to make some changes. And then, Mr. Murphy says to Investigative, and this is the part where,
What page are you talking
page
about?
30, huh?
30 of 161?
Yes, John? I can show it to you. It will be line 4. That is the part where we would want to start, we would have no objection to cutting out page 1 through 29, and then up to line 3 of page 30. So that even includes the portion about Blake. So Judge, that's the portion, notwithstanding that we feel that that portion is important, that the jury should be allowed to hear it because it's relevant.
Yeah, I mean, especially, I'm looking at page 30 of 161 counsels, which I'll include as the next court exhibit in order to August 18th, 2015 interview. Are you influenced, are you under?
And they're
the influence of any
arguing it
drugs,
right now.
alcohol,
This is
medications, or
deja
anything
vu
like
number 7.
that? Mr. Murphy, no. So yeah, that would be admissible because he testified I was high. So,
Right.
okay, all right.
And even at line 13, where he says, all right, I'm not gonna lie.
Yeah, I got it.
Your Honor,
Yes,
may I ask which transcript are we looking at?
August the 18th, 2015,
You said page 30?
30 of 161.
Please tell me it's a different
Page
copy.
sent us something-
There's
oh,
three-
now it's popular.
Yeah, it takes a while to populate,
Okay.
but it should be pages 30 of 161 once it's fully paginated. So what they're willing to do is the state is willing to take out 1 through 20, pages 1 through 29, up through line 3 of page 30, and start at line 4.
No, Steph. Steph says, I roll my eyes so much when love talks, I see crooked.
I advise them.
Actually, when we play her on regular speed, sometimes I feel like my eyes start to like go in different directions. I start zoning out. Playing her on 2-speed with Judge Glanville, how she speaks in front of Judge Glanville, I could see how
Counsel,
the eye
my suggestion
crossing's
would be you go
happening.
through Transcripts.
Look at her face just waiting.
Flag the exact language that you are, that you can agree upon, or actually flag the statements that you are in opposition, that you can't reach agreement. I can rule upon those, but it doesn't sound like that would be the best way that I think the court could probably.
Oh. Okay, well, the feed just did something or other here. Well, anyway, whatever that was. But while we're here, let's look at Brian Steele in his recent motion in limine that had to be refiled about this PowerPoint. He refiled the supplement to the motion in limine on August 9th, just passed, about a clip from the same day relating to the Operation Planters PowerPoint. So let's share that. Let's look back at that. This is earlier in the same day that we were just watching.
Several things I'm going to mark as the next court's exhibits in order. One of them is a motion in
We're gonna
limine
watch
that was
it
filed
faster.
in regards to some regarding the redaction of out-of-court statements of D'Angelo White and law enforcement officers filed last night at 9:49 p.m. By Mr. Sharp and Mr. Stillwell. I'm also in possession of Defendant Williams' motion to adopt and add Stillwell's motion in limine, filed on 4/17 at 8:39 a.m. I'm also in possession of Mr. Williams' motion in limine number 49, which talks about the PowerPoint slide presentation of some 105 pages that references that it's entitled Operation Planners and goes through and has different slides that they're in.
Okay, so Steele included this part to give the context. They're going to argue the
Okay,
thing with Shart first. And then he has us jump to this part, this fun part, this very fun part.
The focus is on why didn't we file this stuff months ago, and let's wind it out and air it out at that point in time, okay? So I'm going to ask the state their issue on this. Are you cutting this out? Did you have discussions with Mr. Sharp? Madam?
We did have discussions.
When?
Well, this morning.
That's too late. The evidence is excluded. The evidence is excluded. I'm going to exclude because I told you that this was going to happen.
This is too late, and this happened 12 minutes into this day. When we started the stream, we were watching like here. And that whole time, Love was like, I'll come in at 8:30 and we can stay until 6:30. And Glanville started seemingly to me with his chastisement of untimeliness and being unprepared. Seemed to steer that over at the defense. But this is happening the very same morning.
No. We're excluding that. And I'm going to exclude the PowerPoint that you all submitted. Well, you're not going to wholesale introduce it.
We had no intention, Your Honor.
All right.
Let's be real clear. We did not intend to introduce the
Being back to the podium.
I personally reached out via telephone and called at least 2 members of the defense team and asked them to call me back. And I would like
But you all should not be identifying this stuff the moment of trial while the jury's sitting in a box. This is the last. I am not going to tolerate this any further. If you don't get together with your colleagues and flag issues and resolve them promptly, and if I have to take them up, remember, I can exclude them. We'll work the weekends, or we'll do a combination of both. So this time, I'm going to exclude those 2 sections.
Your Honor, Mr. Atkins, he confronted this witness with those sections. I last week let them know that we were introducing that.
If the exhibit's not ready and you haven't made, no, well, Mr. Shart's got objections to it.
But Judge, Mr. Sharp can get in and have our evidence excluded every day that he makes an objection
No.
at midnight, and then comes in and says.
Well, then you all should have gotten your stuff together before then. Some of our juries, please. Some of our juries. Have a seat, madam. Have a seat. You better exclude that, and next time, make sure you're prepared.
Judge,
Make sure you're prepared next time. I'm not going to do this anymore. I'm just not. We are starting right now. It's 1:20. So
we have talked to them. We have said we don't agree.
then file a motion and get it before me, and we'll take it up. Both of you all have equally responsibility to do that.
The information they are seeking.
Oh, it's going to be inadmissible right now.
I'm saying, Judge, that you said to file a motion. There's nothing.
I'm not going to have any more discussion about this, madam. I'm not. I don't.
I really think that if this was a male attorney, there would have been a deputy approaching the podium. We saw something sort of similar with Brian Steele the day he was held in contempt.
Well, you know what?
And I attempted to try to talk to them earlier this week.
Well, then that's why we have to.
Your Honor, so the court punishes the state because the defense.
I'm not punishing anybody, but but prior preparation prevents poor performance.
Be prepared, Judge. That's why I sent them what I sent them last week, a whole week and a half ago, 2 weeks. Your
I'm
Honor.
not. Well,
And I have said I would like to discuss.
our jury's coming in, madam. Our jury's coming in. Have a seat.
There's no way the jury can't hear that. The doors can't be that soundproof. And then they come in and sit right next to her face that is clearly scorned right now. Trying to keep a straight face. This happened to be clipped through Law and Crime, so we actually have the end where we had 11 alive cut off. I don't know if they cut off right here, because there's a big break here. But let's see if that's the point, and then we'll go and watch the end of this day, and then we'll be done with this day. We're an hour and 13 minutes into the stream, and we've pretty much seen everything of substance from this day.
I've seen the objection. It's already been made. When a witness is asked the answer to a question, and we want to play it on the tape, they object. It's cumulative. It's bolstering. We've already introduced it. So, Your Honor, we won't solicit.
All right. Well, then you could ask, just a question of, about him about him did, for example.
About what? Okay, this is actually perfect for this super chat. Thanks so much, Zion. So right there, it seems like Judge Glanville's train just got derailed. He was trying to say something and just fizzled out. And Zion here had said, after revisiting a few of these earlier proceedings, I have a little And it has asterisks around little to qualify it. Just a little. More sympathy for Glanville. Glanville probably had to go to therapy for BJS, battered judge syndrome. And like, she really is screaming. Like, I would not want to deal with anybody screaming at me this way. You know, I get, like, if a friend has a bad day or something and they snap and then they're like, oh my god, my bad. That's one thing. But when someone screams at you in a public place, when someone screams at you in a court of law, in a very public place that's being streamed on TV, and you can't get up and leave, and they do it over and over. She did it several times this day alone. I get where your sympathy is coming from, and how that could knock someone off their rocker. I think you're absolutely right, and I also agree with putting little in asterisks there. Thanks so much, Zion.
You know, we follow the rules. We do follow the rules. And there's nothing in the...
Kat, this is probably why. He's deaf, though. This
We
could be
follow
why.
And have...
Let me think about it. Why don't you do that? Yeah, you can have a break and then I'll make a decision, okay?
I think this is where the feed cut. And then they come back for a little bit. And it's a little spicy. It's like...
All right, council, this is the last issue in terms of impeachment. Impeachment under 24-6-607 does authorize questioning or should say calling another witness or introducing other extrinsic contradicting evidence. And of course, the admission of extrinsic evidence for contradiction impeachment is restricted to non-collateral matters. So, but that evidence that impeaches by contradiction is not collateral can be both substantially admissible as well as admissible for impeachment. So, the course of the opinion that, you know, if you've got another witness that can testify as to those statements, that they're admissible. All right? So, Mr. Sharp, you don't have to necessarily do that. 607 authorizes that there's about 4 or 5 impeachment methodologies, so that's one of them. All right? Okay, is there anything else I need to take up? All right, all right, then I will see you all tomorrow morning.
So, the next day is a half day. And again, we got through pretty much everything that was substantial from day 62. This stream has only been on for an hour and 17 minutes. We're watching it, most of it, at a faster speed. But I've been a bit of a pausey McPauserton. But still, that's how much we got to get through in a short time on Glanville time. Day 63 was a half day, so we're going to get through this even faster because there's still a bunch of breaks. So we'll set this one up on 1.5, and Gaither's going to take the stand. And all of that stuff we were watching for day 62 was stuff that you would think should have been sorted out before Gaither was ready to take the stand on that day. But she takes a stand today instead.
Presiding. Superior Court of Fulton County's ninth session. The Honorable Judge, Chief Judge York Glanville is presiding. Court will now come to order.
All right, come on, let's go. Good to see you.
Your Honor, we still missing some people.
Oh wait, what color? What color was Gaither wearing? Was she wearing the black and gray stripes? I can't picture it.
You still may send you the police, Williams and Brian. I'm having nobody to get them.
Okay.
And then make sure that they're not having, film when they come out.
Right. So no, they got film. Let me go ahead.
If somebody come through.
Okay. Oh, they know everything.
Okay.
Anybody else?
I'm missing Brian.
We're gonna skip to when they get the jury in.
It ain't that. When you pull a ham, you need to let them know that, like, both you and Dean here, both, what y'all take off y'all do this. Like, they just really, okay.
Who's hot micing?
Let's see. Traffic got something going on this morning. So we have,
Well, this should be our last stop here.
okay.
I'll be coming back down here. I didn't want to put this on you.
Right.
Sorry, I'm just being nosy about the hot mic.
Oh.
Okay, I think spicy hot mic stopped, so. Got a Doug Weinstein close up. Shout out to Doug. No glasses today. He's ready to hear. Redalius Ryan. Jeffrey Williams.
The state of Georgia versus Khalif Adams et al. In 22 SC 183572. Let me go ahead and take roll for the morning. Mr. Stilwell and Mr. Sharp, Mr. Botts, good morning, gentlemen. All right, Mr. Williams,
The
Mr.
Cheetos.
Steele, Mr. Adams, and Mr. Renard, good morning. All right, Mr. Kendrick and Mr. Weinstein, good morning. All right, Mr. Huey and Mr. Matthews Senior, good morning. All right, Mr. Nichols and Mr. Garner in a very attractive teal suit, good morning. All right. And Mr. Ryan and Misty Williams, good morning. All right, Mrs. Brown and Smith.
Oh my God, okay.
Your Honor, this is,
Ms. Knight, good morning. Mr. Steele, who do you have with you this morning?
Your Honor, this is a second-year Michigan, second-year Georgia State.
Do you have a name? Okay, well, that's usually how we start off. Name would be great. Okay.
Young lady, H-A-L-D-Y, called H-A-L-D-I-W-A-N-G-E-R, called Weimer, and she is able to work with her for approximately a year and a half. Tried cases last year before this case, so 2 years, I guess 2.5. We tried cases together, and she was really rising star in the profession. She's accepted the job starting next fall with the Gap County Public Defender's Office for Cambridge.
All right. Charlie, good morning and welcome. All right, and also this morning I have the privilege of hosting criminal justice cluster from Clark Atlanta University. Good morning, ladies. All right, they're here to observe as this is a public forum and all are welcome within this space. So,
All right, so as we're watching this, and now this is like you notice details like that you don't, especially when I watched a lot of this stuff, I was listening while I was working or something. It's easier for me to pay attention when I'm the one streaming it, right? Because I'm locked in. But when I'm listening to it in the background and doing other things, you miss small things. So they said that there's a group of students from Clark University sitting in and watching this. So they're going to be watching Love do direct questioning, direct exam of Detective Gaither. And maybe we should rate the lesson. We should rate the professor here today.
starting our jurors present?
Yes, sir.
Okay, before I go and bring other jurors, have you all worked out the rest of your edits? What's left?
Your Honor, we have nothing from the state about the initial statement, which is July 15, 2015 by Mr. Murphy to Detective Gaither. It's my position. It doesn't come in. This is the issue we raised with the bench. Mr. Murphy said that he's in fear. He specifically said this has nothing to do with Jeffrey Williams.
Didn't we cover that already though? Yeah, okay.
Excluded, but now I understand the state wants to play all three statements. In addition to that, they did not remove, to my knowledge, from the August 18, 2015 Jacoby Hudson statements. And I just don't know how else.
Okay, well, let me find out first if they removed Mr. Hudson's statements. Okay, have you all removed Mr. Hudson's statements that we talked about?
Your Honor, I submitted a transcript yesterday that had pages 1 through 30 redacted like we discussed in court yesterday.
Okay, so has the corresponding video also been edited?
So because the video is choppy, what the state will do is, since we have to play to evidence reviewer, we're going to mute the portions that are redacted, because if you saw yesterday, the video was choppy, so we don't have a redacted video. But based on the timestamps, Your Honor, and I sent a cheat sheet of all the areas that we plan on muting so that everyone's aware of when we're going to start and stop the recording. Now, if Mr. Steele is talking about areas in which Mr. Hudson may have clarified, so for example, there's a portion of the interview in which I believe either Gaither or Dennis asked who all was in the car. And Mr. Hudson says, tell him who all was in the car. We did not redact that, Your Honor. It's stuff like that that is not redacted. But what we talked about from the first 13 minutes, that's gone. The first 30 pages is gone. And then I believe that portion of time in which he's in the room by himself with his clients, that portion is gone. But
What about the statements involving Mr. Williams at the house and the search warrant?
that's in a different video, Your Honor.
Has that been edited out as well?
That has-
'Cause I don't know how much we'll get this morning today, and we'll see where it goes.
Your Honor, that's from the July interview. And yesterday we did not have the transcript. We got the transcript this morning. So I'm actually in the process of emailing that transcript over to everyone with the page reference of what we plan on redacting, which has to deal with the search at Mr. Williams' home. But that is the July interview, which we just got that transcript.
Okay, all right.
It's not that clean. We got the cheat sheet, and I'm not casting any blame here. We got the cheat sheet at 8:20 this morning. So no, I'm not agreeing with it. And
Okay, well, I'm just asking you because I'll make it for the record and you can make it. And I'll go ahead and make rulings accordingly.
You think this one's
should there
too
be, but,
fast? I think this one's a little
I'm not
fast.
agreeing
Oh,
with
it was on
objections
175.
Whatever the court thinks is within the law.
I didn't mean to put it on 1.75. No wonder it seemed fast. Thanks, guys.
These statements weren't ever.
They don't
Thank
know,
you.
They don't know what the purpose is, other than they're not playing it.
Understood.
So-
I don't have the videos played at all.
Okay, you've said that already.
They have a witness who can testify if it is a prior inconsistent statement. The state's putting in things that are not prior inconsistent statements.
Okay, we had an argument about this yesterday,
And you
so.
said just raise it, they have to be targeted. I'm just telling the court, we're gonna be
But-
objecting.
But yes, but this particular, if you can impeach somebody through another witness who that is contrary to that particular witness. So I think if the state does that through this particular witness, they're entitled to do that.
I don't have a problem with proper impeachment through, in this case, Detective Gaither. My issue is the video is more than impeachment. That's what I'm saying. And I know the court said, hey, it has to be targeted. We're not just wholesaling, putting in these statements. The third statement is the one that is not in.
Third statement in terms of what? Which one?
I apologize.
Okay.
There's 3 statements reported.
Yes.
The third one is February 16, 2016. It's a proffer with Attorney Chada Jimenez and Jacoby Hudson and Detective Gaither and Mr. Walter Murphy, and maybe leaving one person out, but I don't know if I am.
And is that the one that's been edited, Ms. Hilton? as
Yes,
well?
Your Honor. So the proper video is the one that we actually played through Mr. Murphy when he was on the stand. And there were portions that we agreed on and we even muted it, but we actually went back and did an actual physical redaction and redacted out the parts that we even muted while in court. So the version that we gave to defense counsel, I mean, Mr. Atkins emailed that at some point in time yesterday, was based upon what we actually did in court. And so that proffer video should be how it was presented to the jury in court. But that proffer video was already introduced. It's already evidence, Your Honor.
And I'm objecting to playing it again. That's what I'm saying. He agreed with everything. It's not an.
Well, I think there's a disagreement about that, whether or not he agreed with everything. So that's where I'm gonna kind of see where it goes in that respect.
Video was played already. Why?
I know, but it can be utilized for different purposes. So I understand that, but like I said, I'll take it up depending upon what has been said.
So I am not agreeing to anything, obviously, but I'm doing what you said. We'll make objections as we go along.
Okay, all right.
And Your Honor, may we approach briefly?
Can a summary of yours, please?
No.
Your Honor, may I perfect the record, just briefly? Just briefly.
Go ahead.
Thank you. Yesterday, in our discussion of the legality of this impeachment, we talked about impeachment by contradiction, and I just don't want the record to suggest that I'm acquiescing.
No, you have made this objection twice now, at least twice, as to a couple different witnesses. I understand where you head. I understand you made an objection as to it.
Yeah, I just don't think it's, I just want to be clear that I do not believe it's impeachment by contradiction either.
Okay, well, all right, well, I understand that.
Okay, all
That's
right,
your
thank you.
position. Okay, all right, sir. All right. What is it you want to tell me at the bench? Come on up. Do we need a representative?
Okay, bench conference. We'll skip forward a little, but if it looks, we can watch them up there if they show it. They're just zooming in
Ladies
on
and
you.
gentlemen, we are just going
Yawning.
to continue to recess in place. The state's first witness is a few minutes out, so.
All right.
Hey, Doug, you don't mind, we all talk over that.
I'm sorry.
All right. Looks like they don't come back, even though steals seem to be. Oh my God. Oh God. We're just going to go ahead. We're not going to get dizzy on this stream. I always love when it's quiet and the transcription just says E. I guess that means empty, but it's just like E. Gosh, are they back? Yeah, there we go.
That's the
way, in my experience, it's always
No.
been done in federal court.
It can be done. There's some 11th Circuit cases that I was shown yesterday that allow authorized for that. So
I understand that you may be authorized to do that. I was just suggesting that the better practice may be to do it before the jury is present.
Mr. Steele asked me that yesterday.
Okay, thank you, Your Honor.
Yeah, so I'm going to see if they qualify the witness using the Daubert standards in 702, and we'll let you all voir dire the witness accordingly, and then I will make a decision as to whether or not.
Now pay attention to this whole Daubert and the instruction.
In that manner.
Thank you.
Okay,
Your
all
Honor, I
right.
just get a continuing objection.
Yes.
I believe the case, the 11th Circuit case, I think it's where.
You're right, it is where.
Thank you.
Okay, all right.
I don't believe it says that it's done in front of the jury. It said it wasn't done at all, and you have the discretion to find someone. But I
No, it was done, there was no pre-admission. It was done in front of the jury because of the type of case it was. I mean, I think it was firearms or ballistics or whatever else, so.
I think the court just made that fine. Anyway, I'm objecting to it being done in front of the jury. I'm objecting not to have it Daubert heard outside the front of the jury. Can I just have a continuing objection? Because I don't want to do this in
I
front of
missed
the jury.
that.
Okay, all right. Anything else? All right, summon our witness, please. Yeah, I'll bring in the jury. Yes, thank you. Do you want me to give the limiting instruction?
Yes, please. Thank you.
Limon instruction, according to the CCs.
Thank you, Sergeant Ingram. Ladies and gentlemen of the jury, good morning. Good morning. All right, without further delay, we're going to continue with the presentation of the state's case. Call your next witness.
The state calls Investigator Gaither to the stand.
All right, summon Investigator Gaither, please. All right, madam, good morning. If you would come on up, please.
And remember, they're not showing
Witness stand, once you
Gaither,
get
so
there,
they're
if you
panning
turn
while
and
she
face
walks.
Sergeant Ingram, be sworn as a witness before you sit down.
Raise your right hand. Swear firm testimony to give the truth, the truth, nothing but the truth. First and last name for the court.
Lakia Gaither, LAKEAGAITHER.
All right, ladies and gentlemen of the jury, before we hear testimony from Detective Gaither, I'm going to read you an admonition, a limiting instruction, okay? So just bear with me and then we'll go ahead and hear from our witness. You're about to hear testimony from Detective Gaither, who will testify both to facts and two types of opinions and the reasons for those opinions. I will describe all three types of testimony. The first is fact testimony. Fact testimony is based upon what the witness personally.
Now remember, they haven't actually qualified her as an expert witness. But we're getting an instruction of what the jury's about to hear.
Saw, heard, or did. The second is opinion testimony based on the specialized knowledge, skill, experience, training, or education of the witness. The third is called lay opinion testimony. As to the testimony about the facts, it's your job to decide which testimony to believe and which testimony not to believe. You may believe everything a witness says, or part of it, or none of it, or all of it. As to the opinion testimony based on the witness's specialized knowledge, skill, experience, training, or education, you should judge this testimony like any other testimony. You may accept all of it, part of it, or none of it. You should give it as much weight as you think it deserves, considering the witness's knowledge, skill, experience, training, or education, the reasons for the opinion, and all other evidence in the case. As to the lay opinion testimony, this testimony is based on inferences drawn from the witness's direct perceptions and must be rationally based on those perceptions and not on speculation or what someone else has said. You should judge this testimony like any other testimony. You may accept all of it, part of it, or none of it. You should give it as much weight as you think it deserves. When considering lay opinion testimony, however, you should not give it any extra credence based on the specialized knowledge, skill, experience, training, or education of the witness. You should also consider whether the witness testified to personal observations or involvement of the fact. It's a fact witness testifying about a lay opinion based on the witness's perceptions or testifying to an opinion based on specialized knowledge, skill, experience, training, or education. When a witness provides opinion testimony based on knowledge, skill, experience, training, or education, that person may rely upon facts that are not based on his or her personal observations or involvement, but that opinion cannot serve as proof of the underlying facts. The fact that a witness is allowed to express opinions based on a person's specialized knowledge, skill, experience, training, or education should not cause you to give that witness undue influence for any aspect of that person's testimony or otherwise influence your assessment of the credibility of that witness. All right, madam, you may proceed.
Thank you, Your Honor. And just up here, Your Honor, I will be attempting to qualify.
Objection, speaking.
I'm going to overrule it just for a second, just to see where she's headed. Okay, Mr. Steele? All right.
The order of the questioning will be first as an expert and then as.
So you're gonna qualify?
I'm going to.
Okay, all right,
Yes.
all right, go ahead.
Thank you, Your Honor. Good morning. And is it still Detective Gaither?
No. Good morning. No, good morning.
Thank you. Now, are you retired
Yes.
from police work?
Yes.
Would you tell the jury what kind of work you currently do?
The microphone, please.
Which,
The one you're saying.
I'm afraid it's already on.
Okay.
If you can speak into it, Ms. Lowe. Thank you.
I don't think it's working, but I will speak up.
I heard it. If you stand next to it, it'll pick up. Detective Gaither, if you could just also speak in the microphone.
Yes,
we'll be able to hear you. Okay, thank you.
I like Keith Adams' tie.
Would you tell the jury what kind of, are you still in law enforcement?
No, ma'am.
And how long has it been since you left law enforcement?
4 years.
Did you retire from law enforcement?
Yes.
How long did you work in law enforcement?
Almost 19 years.
Would you please tell the jury?
His
where
jacket
you were
is sitting
originally from?
nice.
Chicago, Illinois.
What part of Chicago, if any particular part?
Objection, relevance.
Your Honor,
Overruled.
go ahead.
South side of Chicago, Inglewood community.
And is Inglewood E-N-G-L-E?
Yes.
W-O-O-D? And did you grow up in Inglewood, in the Inglewood community of Chicago?
Yes.
So did you go to grade school and high school there?
Yes.
What high school did you attend?
Bowen. Bowen. Bowen.
And I'm standing over here, so,
Yes.
the last year in here. While you were,
Overruled. Just go ahead. Go ahead.
while you were growing up in Inglewood, were there any gangs in your neighborhood, as you understand?
Overruled, sir.
Yes.
And did you know about them while you were growing up?
Yes.
How did you know about them?
Just friends, going to school, gang members, the community. In Chicago, gangs, it's kind of like culture. So you're very aware of gangs at a young age.
Now, when you say it's kind of like culture, would you explain to the jury exactly what you mean?
Gangs in Chicago were very prevalent from my parents, my grandparents, all the way to me. So just gang lifestyles, what to stay away from, what to look for. It was very well known at a young age. So
And who was it that gave you the information you had at that time
Objection.
about, and I'm not asking what they said,
I'll rule the objection, Mr. Foreman. Go ahead.
who was it that gave you the information that you used to just conduct yourself on a day-to-day basis as it relates to gangs?
well, I'm the youngest in my family, so I have older brother, uncles. We all live together. My mother, so just family, really. What to look for, who to stay away from.
And while you were growing up, what gangs did you know about that were there in Inglewood?
Objection, Your Honor, relevance.
Overruled, sir.
In my neighborhood, it was Gangster Disciples and Black Disciples. Where I went to school was, I believe it was Black Pea Stones in that area. So it's two different gang sets.
And I heard you say friends and family, I think.
Yes.
Did you know anyone who was actually associated with or a member of any particular street gang?
Yes.
What was your relationship to the people that you knew who were in street gangs?
I have family members, friends, high school friends.
And did you interact often on a daily basis with these people who were also gang members?
You can't choose your family, but, of course, family, but friends, you knew to be cordial with them at school. But, outside of that,
What
my
is
family
Steele
did a pretty
doing
good
to
job
that
of keeping-
highlighter?
Relevance.
I'm gonna overrule the objection, Mr. Steele.
My family did a pretty good job of keeping myself and my siblings away from that.
Now, were you afraid to interact with them when you were growing up with your friends and family who were involved with gangs?
Objection, relevance.
I sustain the objection.
The chorus.
And did you have to comport yourself in any particular way as it related to gangs in your neighborhood growing up?
I would say so. I mean, we were taught at a very young age about certain colors you don't wear. Back then in the 80s and the 90s, the thing was,
I'm overruling the objection, sir.
the manner in which you wear your hat, whether it was to the either side or backwards, clothing attire, based on particular neighborhood that you lived in or frequent, that was a pretty well-known fact not to do or just be aware of.
Now, did you personally ever get involved with any gangs in the neighborhood?
No.
And did you actively avoid run-ins with gang members in the neighborhood that were not your family?
Objection, relevance.
I sustain the objection.
How large was the neighborhood that you grew up in?
We had to compare it. I mean, Inglewood community,
I feel like this is why she doesn't want her
Several
face
miles,
to be
maybe,
shown because it's embarrassing.
9 square miles, if that.
Did I hear you say you have to compare it?
Yeah, if I were to try to compare it, I mean, to something here in Atlanta,
Cleveland Avenue area of Atlanta, are you familiar with that area?
yes.
How do you know about the Cleveland Avenue area of Atlanta?
Just from working investigations and frequenting the area doing work
But remember, there's a class
Using-
watching
Did I hear you
this
say frequency
day,
area
this
doing
trial
work?
day.
during work.
Okay. And using the Cleveland Avenue area of Atlanta,
Mhm.
can we use that? How would you describe Inglewood when compared to that area?
In comparison, as far as size, or
As far as size, culture,
I stand the question.
start with size.
Inglewood may be a little larger than Cleveland Avenue. I would say about, if you guys are familiar with Zone 3, Zone 3 is one of our larger zones. Inglewood would probably be the same size as Zone 3.
Thank you. And how about in terms of socioeconomic status? How would you describe the Inglewood area that you grew up in as compared to the Cleveland Avenue area?
Objection, relevance.
Overruled.
Uh,
Go ahead.
Go ahead and answer it. I'm gonna rule that objection as well.
It's roughly the same. I mean, you do have your crime. You do have financial issues between families, but there are good, hardworking people in the neighborhood as well. So roughly the same.
Now, when did you leave Chicago?
After high school,
And what year was that?
you showing my age.
Sorry.
98.
All right. And what was it that led you to leave Chicago?
Thought I wanted to go to college, so I went.
So where did you go to school?
In West Virginia,
What school in West Virginia?
West Virginia State College.
Now, you said you thought you wanted to go there. Did you know growing up that you wanted to go to college?
No,
Overruled.
no.
At West Virginia State College, did you declare a major?
Objection, relevance.
What was your
Overruled.
major?
Criminal justice.
Did that major have anything to do with the neighborhood that you grew up in or your contact?
Relevance.
Why did you choose criminal
I'll
justice?
sustain the question as to form.
Still relevance.
I'm gonna overrule the objection, Mr. Sharp.
Why did you choose criminal justice?
We know if 1.5
I had no
is
clue.
good.
I mean, I never wanted to be law enforcement. I grew up watching the TV shows, Law and Order, Cops. I thought it was interesting, but I didn't have a desire to be a police officer.
Now, did you graduate?
I did not.
Why did you leave before graduating?
Financial reasons, in school and at home.
Where did you go when you left West Virginia State?
Atlanta,
And what year was that?
2000, late 2000.
How old? Never mind, I'm not gonna do
I'm
that.
done.
When you got to Atlanta, what did you do
I
in terms of employment?
think I worked a retail job for a short period of time.
Did you do something different after that?
APD, Atlanta PD.
All right. What made you apply with the Atlanta Police Department? What made you choose that particular agency?
Honestly, I was just giving a friend of mine a ride down to Atlanta Police Headquarters to apply. And he suggested that I come in and apply as well. So there's no intention of doing it.
All right. Now, once you applied, did you have any idea of what role you wanted to play in the police department?
No.
And when you first came to Atlanta, culturally, was it the same, different than, or in some ways both, to where you grew up in Inglewood?
Objection, Your Honor. Relevance.
I'll sustain the objection.
Is it as the foundation, or do I need to?
I'll stand as the relevance. You can
Okay.
lay more foundation.
Thank you. When you first came to Atlanta, did you personally, at that time, know about any gangs in the city of Atlanta?
No.
And did you personally, at that time, recognize any signs of criminal street gang activity in the city of Atlanta?
No.
What was your first role at the Atlanta Police Department?
I was a patrol officer in Zone 4, Southwest Atlanta.
What parts of Atlanta made up Zone 4 at that time?
West End area, Cascade, the northern part of Martin Luther King, the western part of Martin Luther King, Fairburn Road, parts of Camp Creek, Campbellton Road.
Now, as it relates to Zone 3,
Mhm.
where was Zone 4 situated in Atlanta? Were they next to one another, separated by another zone or something different?
Parts of Zone 3 do border Zone 4. If you're down on the eastern end of Zone 4, like around Lee Street, West End Mall area, that borders the western part of Zone 3, Mechanicsville, Pittsburgh neighborhood, Deal Avenue. And outside of that, everything else is kind of on the opposite side. Zone 6 is the other side of Zone 3.
Okay. And so was it your testimony that the Mechanicsville, Pittsburgh, and Deal Avenue area of zone? I'm trying to get clarity.
I'll
Clarity to the question.
overrule the objection, sir.
Were those areas, the Mechanicsville area, Pittsburgh area, and Dale Avenue area in zone 3?
Yes.
And did they abut zone 4?
Lee Street was basically the border between zone 3 and zone 4. So Lee and Abernathy was kind of the barrier between the two zones,
Okay.
if you had to break them up.
Did you interact with people from zone 3 as well as zone 4, or did you only interact with people who lived in zone 4 at the time that you first started as a patrol officer in zone 4?
I mean, citizens or police?
Citizens? Yes.
Yeah, I mean, there's no barriers for citizens in Atlanta. They come to zone 3. Our zone 4 citizens go to zone 4. It's not like police work where you're kind of restricted to a certain area. Citizens, they can move back and forth, come in contact with all types of people.
Would you tell the jury what your responsibilities were as a patrol officer in zone 4?
I was assigned to Evening Watch, which is 2:30 to 10:30, I believe. Responsibilities included answering 911 calls, traffic accidents, directed patrols, that type of thing.
Describe for the jury a typical day at Evening Watch for you in zone 4 as a patrol officer.
Just a typical day.
Your Honor, on the statute.
I'll just answer one, you can rephrase.
You know, I think this is actually a great time because I see some of you guys alluding to it in the chat. But just to reference this throwback, I'll drop a link to the article. But this is Detective Dennis. This is Detective Gaither. That's who we're hearing testimony from right now. These are the ones that were in the striped sweatshirts in that one Lil Woody, Kenneth Copeland interview video. But remember, they were named Investigators of the Year, both of them, together, by APD in 2025. So all of these police interviews that we are watching with Woody, and then now we're going to see a bunch from DK, that's the work they were doing, and they were rewarded for it jointly. And then they both retired together in August of 2020, blaming inter-office politics and a lack of respect from higher-ups. So, there you go. These are some of the more experienced officers we had that are leaving. So, I'm going to drop this link in there, but there's a little bit of interesting context there to who Gaither is and also Tyrone Dennis. Share the screen. I'm Boomerang. Hold on. I'm just staring into space reading comments.
I'll just answer one, you can rephrase.
There we go.
Was there any
I'm imitating Detective Squirrel Brain for a minute there.
As a patrol officer in zone 4 on Evening Watch?
Well, Evening Watch was the busiest time of day for police officers. So by the time I got to work, we would have a bunch of calls and attendance, calls holding for officers to respond to. So the first several hours of my day would be trying to knock down our pending of all the calls that came in previous before I came to work. So
Say that last part again. I didn't hear you. The first part of your day was what?
was trying to help with the pending calls for service that were just sitting in the queue waiting on the officers to respond to. So the first half of my day was that, just trying to get the pending down. We would come in, it would be 30 calls in the pending back then. So and the second part would trying to play catch up until you learn how to work your day.
All right. Now, as a patrol officer, did you actually investigate cases that occurred in zone 4, or did you only respond to the cases?
No, my responsibility was a first responder, which is when someone calls 911, the first officer that responds to your house or whatever scene that the call was. I would take the initial report, and if it needed to be forwarded to a detective or an investigative unit, it would then be forwarded to that unit.
And what was the difference in what you did as a
Hey,
patrol
Miss
officer
Kim,
and what
thank
did
you.
that same
Hello, hello.
circumstance that you handed over?
Really, I was just the initial responding officer to gather whatever preliminary facts about whatever case or incident it was and document that. And that would then be forwarded to the investigator to further look into and investigate crime.
As a first responder on Evening Watch in zone 4, how often did you have personal contact with the citizens of zone 4?
All day, every day, all the time.
And was that contact only when you were arresting someone?
No.
Was it only when you were investigating a crime though?
No.
What opportunities did you have to interact with the citizens of zone 4 outside of arresting somebody or investigating a crime?
I kind of learned how to work my day. I wasn't a fan of answering 911 calls, accidents. So I just kind of became proactive where
We're going to play
I was
that twice.
answering 911 calls. I kind of learned how to work my day. I wasn't a fan of answering 911 calls, accidents. So I just kind of became proactive where I would get out in our high crime areas, places where we knew people would loiter. I would just get out, talk to people. And, you know, if I was able to make an arrest, I would. If not, you know, just getting to know who was on my beat and the beat surrounding my beat was really my day. And by doing that, that kind of took me away from having to answer 911 calls. So.
Now,
Sorry, Ms. Love, 1 second. Is your microphone on?
this one?
Yes.
It's on, but I think that the battery is dead. I turned it on, it's on, there's nothing.
What kind
no
of,
light.
what kind of battery is that?
Does the court prefer that I wait or,
Or just go to that central mic so we can all hear you, because that's a problem. So,
okay. Am I heard if I speak right here?
not as well as you probably were in the central mic. Hold on, we're gonna see if it's working.
I'll just carry on right here while he's getting that. Thank you.
Oh my goodness.
Is this better?
Yes.
Okay, thank you.
We're all like, no.
Now you said that
No.
you spent a lot of time getting to know your beat. Was it your goal when you were getting to know your beat to go out and make arrests? Was that your main priority?
No,
What was your priority when you went out to know your beat?
really the priority was to stay away from 911 calls. I mean, if we're being honest. So if that included, you know, just doing directed patrols, doing drop-ins, which is my business on my beat, I would go into the stores, talk to the store owners. You know, the old guys sitting on the side of the building drinking, you know, they give you a lot of information. So my priority wasn't to lock people up. I wasn't trying to be on I-20 doing accident reports.
All right. How long did you stay in patrol at Zone 4?
A little over a year.
Is that the normal time that a new officer stays at that level?
No,
What's usually the time? Is it more or less?
probably more.
So did you get out generally earlier than normal?
I did.
All right. Now, what happened that caused you to leave patrol in Zone 4 earlier than normal?
I guess my supervisors figured me out and they put me on the 15, which is a field investigative team. It's plain clothes. You do proactive work. So
When you say figured you out, what do you mean?
Plain clothes, the striped clothes, love and life, not having to answer calls. You can wear sweatshirts all day. It's like working from home, except you're just making your home that interrogation room for pretty much half of 2015. And yeah, Fletch says Glanville for Judge of the Year for Fulton County. You know, he's decorated, so you're saying that now, but you never know. It could happen. It could happen. And thank you so much for the super chat.
Me?
they saw I wasn't answering 911 calls, so they used me in a better capacity.
When you say proactive work, please explain what you're talking about to the jury. What do you mean?
For me, just getting out your car, walking around, talking to groups of guys. Again, if it led to an arrest, it was an arrest. If it was a traffic stop that led to an arrest or seizure of guns, drugs, that's just what it was. It's just being just proactive, just getting out your car.
And did you want to get to know your community as well?
I did.
Did you live in that area while you worked in that area?
No, I actually lived in Zone 3 at the time.
What area of Zone 3 did you live in, generally speaking?
Carver Homes.
Does Carver Home still exist?
It does.
Would you tell the jury what the Georgia Peace Officer Standards and Training Council, or POST, is?
That's the council that certifies people to be police officers in the state of Georgia.
And were you POST certified while you worked at APD?
Yes.
Are there different POST certifications or just one?
I'm not sure.
Okay. Did you have to do anything to remain POST certified while you were at APD?
Every year we would have in-service, which is your yearly certification that the police department gives you to keep your post certification. You'll be firearms qualifications, updates on Georgia law, stuff like that.
And did you remain POST certified while you were at the Atlanta Police Department?
Yes.
Was maintaining POST certification a requirement of your employment at the Atlanta Police Department?
Yes.
When you said you were assigned to the field investigations team, when exactly did you start in that group?
Roughly 2004, maybe late 2004, I believe.
All right. And what personally, beyond what you've already explained, did you do within the field investigations team?
As far as day-to-day activities?
Yes.
Day-to-day activities would include, again, being proactive, doing drop-ins at our local businesses. We would respond to areas that were considered hotspots within the zones. That information would come through crime analysis and our supervisors. We would do low-level narcotics buys. Yeah, that's really it. Whatever was going on, or not whatever was going on, whatever area within the zone was considered a hotspot that week, that's the area that we would concentrate on, whether it was for robberies, drug sales, shootings. Yeah, that's just the area that we would focus on.
And you said hotspot. Is there another phrase or term for hotspot? What does a hotspot mean?
Like a high crime area.
Okay. And you said that that information came from crime analysts and supervisors?
Yes.
Is that information that the general public would have access to?
If they looked hard enough, they could probably find it, but generally it was within APD.
All right. Did you only work within Zone 4 with the FIT team, or did you work all over the city of Atlanta?
We would cross borders sometimes, but for the most part, maintained in Zone 4.
And is that where you were assigned during your entire tenure with the FIT team?
Yes.
Now, is the FIT team the same thing as the Red Dog unit at APD, or is that something totally different?
Absolutely not. It's completely different.
Oh, okay. Did they have anything to do with one another?
No.
All right. And how long did you say you worked at FIT, in the FIT unit?
About 3 years, 3.5 years.
Were you always in plain clothes, or did you sometimes wear a uniform while you were working in that unit?
At that time, the only time I put on a uniform was to go to my extra job. Other than that, I was in jeans and a t-shirt.
Did having a uniform versus not having a uniform make your interactions with the citizens any easier or any harder, as you observed it?
Objection, relevance.
I'll overrule the objection, sir.
My experience, I felt like the uniform kind of was a distraction. A lot of people would just look at the uniform, like they wouldn't look at the person.
I'll overrule the objection, sir.
They would look at the uniform and not the person or what you were saying. So it became a lot easier for me just to even maneuver to get to talk to certain people in plain clothes, jeans and a t-shirt. It was a lot easier than the uniform and a patrol car.
And as a FIT officer, did you investigate crimes, or did you respond to crimes, or did you do some hybrid?
It really just sounds like she hated wearing the uniform. Which I kind of understand, because it seems like kind of clunky. You got a lot of stuff attached. But
Both.
We did both. The high priority calls like the shootings or robberies, we will respond to, but we did conduct a lot of our own investigations.
And during your time in the FIT team, to your knowledge at that time, did your investigations ever involve gang activity that you knew of at that time?
Not from what my idea from where I grew up was actual gangs. So during that time, 2004 to 7, 8, no, I didn't. That wasn't my focus. I wasn't necessarily paying attention to it. So I didn't, obviously, because I didn't recognize anything that I was familiar with as far as gangs in Atlanta. So.
And again, what is it that you were familiar with, or that you were looking for, or would have expected to see as it relates to gangs, to tell you that there's gangs here in Atlanta at that time?
Probably the graffiti, the manner in which, people wore their clothes or their hats, the hand signs. That just wasn't, I wasn't focused on that because I didn't see those familiar signs here in Atlanta that I knew of.
Doing the math, if you stayed with FIT about 3.5, 4 years, did you leave in 2007?
Yes.
And what happened? Why did you leave the FIT team?
I was asked to go to the gang unit.
What year did you start in the gang unit at the Atlanta Police Department?
2007.
When you first joined the gang unit, what was your position there?
I was an officer.
Were there both officers and investigators in the gang unit?
It was myself and one other officer, and the rest were detectives.
Would you tell the jury at that time what difference there was between an officer and an investigator in the gang unit? Was it the same as?
Money.
Oh, okay. All right. So even as an officer in the gang unit, unlike as a patrol officer, in the gang unit, would you actually begin to investigate your own cases?
Not initially. I mean, I didn't really know what I was doing. It was just you go to the gang unit. You had more freedom and access to move around the city, learn different parts of the city. So I didn't know much about gang investigations. I knew how to investigate a little bit just based on my time on the Zone 4 FIT team. So I just kind of reverted back to what I knew, which was being proactive and not necessarily working gang investigations because I wasn't aware of how to do it.
And you took me to the very next question. At that time, by the time you had reached the gang unit, when you first joined, had you had any formal training in criminal street gangs?
No.
Had you had any formal training in identifying or investigating criminal street gangs before joining the gang unit?
No, I didn't.
Did you know why you were assigned to the gang unit when you had no formal training in either gangs or criminal street gang activity?
Objection, also speculation.
I sustain the objection.
love the group objections.
gang unit, did you obtain any formal training on criminal street gangs in Atlanta?
Yes.
Now, when you joined the gang unit, did Georgia have a formal definition for a criminal street gang?
Your Honor, that's called the law. I will object.
I sustain the objection.
Did you, at the time you joined the gang unit in Atlanta, were you aware of any formal definition of a criminal street gang utilized by the Atlanta Police Department?
No, I didn't know gangs existed in Georgia.
At this time, or at the time that you left the Atlanta Police Department, did the Atlanta Police Department use Georgia law's formal definition of a criminal street gang in making charging decisions in criminal cases?
You said at the time that I left?
Yes.
Yes.
And again, when you first joined the gang unit, did you know of any formal definition of criminal street gang activity?
Sustained.
Is there a distinction between criminal street gangs and criminal street gang activity?
Law, Your Honor.
Your Honor, I have to ask to test her knowledge as it relates to what she did.
It's not accurate. It's the law.
I sustain the objection. I sustain the objection, madam. She may be able to, I don't think it's
I'll
correct.
rephrase.
All right.
During your time in the gang unit, as you progressed, did you recognize in your work, did you employ a distinction between criminal street gangs and criminal street gang activity?
Yes.
I'm gonna overrule the objection, sir.
Yes.
Okay. Let's talk about what training, if any, that you got while you were at the gang unit. First, let's start off. How long were you an officer in the gang unit?
I went to the gang unit in 2007. I was promoted to detective in, shoot, don't give me the line. Maybe 2012, maybe 13. I'm not exactly sure of the dates, but from 07 to, I was promoted to sergeant in 2016. That entire time I was in the gang unit as an officer and a detective, so from 2007 to 2016.
While at the gang unit, what were your sources of information for gangs and gang activity if you had no formal training before getting there?
Once I got the training, I mean, I got to know a lot of people within the community.
And this is actually a good point because, I think a lot of people have heard that, I think it was Gaither and was it Detective Quinn that both were on the first 48, right? I think it was those two, but maybe there's a third one. But in any case, you're so concerned about your face being on screen while you're testifying in trial now that you're retired, but you did first 48 episodes. So how does that make sense?
Good and bad. And a lot of my gang knowledge information really came from them. We did have meetings with other jurisdictions and information sharing within our department and our unit. But if we're just speaking about Georgia gangs, the gangs within Atlanta,
Yes.
a wealth of my information just came from the community and gang members themselves.
So let's break that down just a little bit. When you say it came from your contact with people in the community, good and bad, what do you mean when you use those terms in this context?
Just normal citizens, people that don't commit crimes. And then when you commit a crime, just interviews with suspects, people who are arrested, you do get a lot of information from that as well.
At the time that you joined the gang unit, what were the focuses? What did the gang unit mainly do within the city of Atlanta?
I would say relevance, Your Honor, is what I'm talking about. That's relevant.
Your Honor, it's relevant. It's relevant. Establishing background. The juror has to gauge.
I'll sustain the objection, sir.
You sustain it, Your
No,
Honor?
I'm gonna overrule the objection.
Thank you.
All right.
At the time that you joined the gang unit, what was the primary focus of the gang unit? What type of investigations?
I don't know what they was doing, honestly. I know we had a couple of people that did homeland security investigations involving threats against officers or organized crime. It wasn't street gang investigations, to my knowledge. They were doing some other stuff.
And what type of formal training did you get while you were in the gang unit, if any at all, on criminal street gangs and recognizing and identifying criminal street gang activity?
She's asking if any at all to make it a passable question, so she doesn't get an objection for leading. But it's so funny, coincidentally, that we're all curious, like, what is this caliber of training that you get? What experience do you actually have? So love trying to make sure she doesn't get an objection just seems like a hilarious question, coincidentally.
My first couple of years within the gang unit, I did a little bit of training, just gang identification. It was roughly 40 hours or so within my first couple of years. And after that, I was just sadly too busy within investigations to kind of do much formal training.
Let's talk about that 40 hours that you did get. What type of information did you learn during
You
that
got to be
40
busy when
hours
you're doing these 9-hour interviews with
Just the
People like
basic
Kenneth
gang
Copeland.
identifiers, how to recognize a gang, crimes that gangs generally committed. I'm not gonna say that it was worth anything, but a lot of the instructors were not from Atlanta or worked the Atlanta area, so a lot of the information was really general, loosely based on national criminal street gangs, the traditional gangs.
Were you educated about the laws of the state of Georgia in that training? And
Yes.
were you educated about how to apply the laws?
I stand as the form. You can rephrase, madam.
Yes, Your Honor, thank you. Did you learn about the laws of Georgia as they related to criminal street gangs?
Yes.
I stand objection, Mr. Foreman.
Yes, Your Honor. What kind of information did you learn as far as laws were concerned during your training with the gang unit, your formal training?
The Georgia laws regarding criminal street gangs.
Did you learn anything at all about applying those laws?
We did. We learned basically what the state considered to be a gang and what particular crimes or activities were considered criminal street gang activity. There was a difference between the actual two. It's two separate meanings.
And did you use that lesson, those lessons that you received during your formal training on a consistent basis while performing your duties within the gang unit?
Yes.
I will rule the objection.
Yes.
Did the gang unit that you described when you first went there doing different things, did it continue operating in that manner, or at some point did it shift its focus?
Definitely think it shifted its focus roughly 2010 or so.
What types of things led you to recognize a shift in the focus of the gang unit?
During our daily activities or investigations of various crimes that were not initially considered, gang related, we began to see identifiers of gangs now operating in the city of Atlanta. We would see graffiti. At that time, social media became more.
Sir, you have an objection, sir? Basic.
History is irrelevant. History is irrelevant. The witness understand.
Her background is what?
It's relevant, sir. I'm gonna overrule your objection, okay? You may have a continuing objection, sir.
Please continue.
Social media started to become a thing. It was new. It was new to us. So we did rely on a lot of social media information to the intelligence gathering. Our local gang members at the time would bolster their gang affiliations on social media, which kind of, was surprising to us because we really hadn't seen that before in that manner. So around that time is when we kind of start putting the pieces.
I think that's also really interesting because you're saying you're new to social media. Social media wasn't all that new in 2015. But if you're saying you're new to it at this point in time, then the way you went about gathering evidence in 2015, how do we know how well authenticated that work was?
Pieces together with people that we had already previously identified for particular crimes throughout the city. They were now identifying themselves as part of whatever particular gang.
When you said that you began to...
Casper, this is crazy.
Let me hear the question first.
When you said that you began to recognize identifiers, what was it that allowed you and the other members of the gang unit that you worked with to recognize things that you had not recognized before?
I'm gonna allow it, Mr. Steele.
You may answer.
Well, definitely the training that we had received and understanding of, my understanding of the law. We would see kids wearing T-shirts and hats and stuff with acronyms and words under it, and the involvement that we had within the community to just get out and talk to people or ask, what does that mean? They were pretty proud about, telling us what it was and what it meant.
We're not asking us to listen.
Yeah, I'm gonna overrule the objection. Overruled. Overruled. Did you get those people, Christina? Okay, all right.
You may continue. So you said that they would talk to you.
Overruled, sir.
Please continue with what you were saying.
I don't even know what I was saying. I'm sorry.
You said that the people, did you say
Overruled, sir.
that the people that you interacted with would talk to you? You were saying how you were describing your interaction.
Correct. Yeah, just getting out talking to folks, not just people you arrested, but just normal citizens within the communities, grandmas and uncles.
That also stands.
Feeling so annoyed.
Beginning to recognize signs of criminal street gang activity.
Mm-hmm.
What else, if anything, allowed you to recognize things and signs that you had not recognized before? Besides training, formal training.
Yeah, definitely the different clothing that we would see. Certain people start to wear The social media with the post, and you can add a caption to it. A lot of that during that time was, this is my gang, and hand signals that we weren't accustomed to seeing. Graffiti throughout the neighborhoods. At the time, 2011, 10, 11, 12, we had a lot of school fights that really weren't a thing before, because during our daily duties, we would respond to a lot of the schools to try to do preventative gang work. So we did see an uptick in, I don't want to say gang fights, but two groups of kids fighting. We would see that.
And when you were involved in working in the gang unit, did you consider it a crime to just simply be in a group wearing the same shirts as you described earlier?
Objection to witness considering a crime.
Your Honor,
What's the basis for your objection, sir?
The law, so it went beyond what a witness can testify about. Sure, it's a decision.
Okay, I got you.
Your Honor,
Go ahead, I'm sorry.
it goes to her qualifications and knowledge in this area.
I'll rule the objection. You may answer the question now.
I'm sorry, what was the question again? I apologize.
And when you were involved in working in the gang, did you consider it a crime to just simply be in a group wearing the same shirts as you described earlier?
No.
Did you arrest people for making hand signs?
No.
Did you arrest people for using certain hashtags?
Kind of continuing objection.
Yes, you may, sir.
You arrest some unknown person for doing something, some unknown sign.
Your Honor,
Object.
She's got to lay a foundation, so you can object. I'll go ahead and make a continuing objection, okay?
And there's no foundation for a request.
Overrule, sir.
Relevance.
Overrule, sir.
when you were describing what you saw and recognized as signs of gangs appearing, what other signs did you see besides the ones that you just described to the jury?
I mean, on top of my head, I think those were the main ones. I may be missing a couple, but I think those are the main ones.
Did you ever hear any language that was used by groups of people consistently that was sort of different from the average?
Convey and hearsay.
I'll sustain as to leading. The other two I'll overrule. So you can rephrase, please.
Thank you, Judge. Were there any linguistic styles that you noticed as signs of gang presence?
Yes.
Describe what you mean when you say yes.
We, at the time, again, social media was a very informative tool that we used. You would see gang language from Bloods to Crips, the usage for Bloods not using the letter C. So they would cross out certain letters that were synonymous to rival gangs, like the Crips, and replace it with a B or an X. We would see Crips doing the same thing. They wouldn't use the letter B in language that, in raps, hashtags, captions, even on graffiti. We would see graffiti being crossed out if in certain neighborhoods that we knew a particular gang operated in, we would see the next day they have an X through it. So yeah, it was definitely in the language that they used, slang.
Did you see any correlation between those signs that you saw and any particular criminal activity in areas of Atlanta?
Are you asking what particular areas did we see it in?
Yes.
When I went to gangs, we were citywide, so that was my first time really able to cross the borders of Zone 4.
Watching this on replay just makes me extra mad now that we just saw this week Love talk about how drip means, it's a blood term that means you're dripping in blood from having just committed a crime, a violent crime against somebody. And now we're hearing Detective Gaither, one of the state's repetitive witnesses, gang expert witnesses, talking about the letter switching. But they just said, Gaither just said, social media was new to us. And half of these things that they're going to reference with these switching letters are going to be from captions or videos posted on social media. So you're assuming that this is tied to gang culture. You have no awareness that if you go watch enough TikTok, you'll see the same thing happening. Like, maybe not TikTok in 2015, but on Twitter, when it was still Twitter. Like, this is just nuts, watching it in retrospect.
Zone 4 definitely had a lot of blood gangs within it. We did have some gangster disciples around Fairburn Road area. Zone 3 was predominantly Bloods, but we did still have a lot of hybrid neighborhood gangs that weren't really identifying with traditional national gangs.
Did agencies or units within the Atlanta Police Department share information as it related to gang intelligence?
Yes.
Would you explain how that occurred?
Yeah, so we would have monthly meetings with surrounding jurisdictions that included DeKalb County, Clayton County, Fulton County, and it was really just information sharing. At the time, criminals didn't necessarily have a border in which they stayed in. If you're a criminal, they operated everywhere. So we definitely had to come together and collaborate with information gathering to try to put a hold on crime.
And what kind of information did you all share within these monthly meetings with other law enforcement agencies?
Gang trends, crimes, really gangs and crime trends.
What sort of crime trends did you, within the gang unit, begin, if any at all, did you begin to recognize during the time that you actually started to see signs of gang presence in Atlanta?
Definitely the smash and grabs. That was the first real trend that I saw. We had guys that operated within Atlanta that would drive cars through buildings and steal blue jeans, steal flat screens. That went on for several years. I mean, at least 4 years of the smash and grab robberies and burglaries were the thing here in Atlanta.
And how, if at all, did you correlate that with the rise in gang presence? How did you all within the unit make any kind of connection between the two?
I feel like that's a social media factor too.
We previously identified them as being associated with neighborhood cliques or hyper gangs. That kind of made the connection of almost like a spider web of once you kind of find one or two, you definitely find the other 6 or 7 guys. So just previous run-ins with gang members, whether it's during an arrest or just general contact, citizen contact.
Would the general public have access to the information you shared with other law enforcement agencies in these gang intelligence meetings that you held monthly?
No.
Did you have access to any other sources of gang intelligence during your time with the gang unit besides information sharing sessions?
I can't think of any right now.
When you made arrests in certain crimes, did you all collect evidence that contained anything that informed you about gangs? Like,
yeah.
And what type of evidence?
Later on, we started finding a lot of gang Bibles, which are basically their bylaws that the gangs operate off of. We would find, again, like I stated, the T-shirts and hats with gang insignias and markings on them. I think that's about it that I can think of right now.
Were cell phones being used in the time?
Absolutely.
Cell phone is the form. You can rephrase.
Yes, Your Honor. Did you ever collect anybody's cell phone?
Yeah, cell phones were very informative and key pieces of evidence when gaining gang activity or signs about gang activity.
Why?
Well, the camera phones and were being used to memorialize gang activity. If a person was arrested and there was probable cause to search their cell phones, we would apply for search warrants, get that information back from cell phone companies, and do a search of the actual phone, and we would find a lot of evidence regarding gang activity.
Did you ever get search warrants for other things like social media?
Yes.
What was the purpose for getting a search warrant for a social media site?
Foundation for the question.
I stand the question. You lay a little more foundation.
Why were y'all interested in people's social media sites?
Just based on the information that the user would put out. If our focus was gang, if our focus was gang activity, our local gang members were making it known to put it on social media so it could be displayed to the public. So it was definitely a key piece of evidence that we wanted. There would also be direct messages, which is like a DM feature within social media where you can communicate with anyone who was on your page, whether they were local or from around the world. And that information was very key in gathering information about national street gangs and the traditional gangs that were not operating in Georgia at the time. We did get a lot of information from the direct messages and text messages within cell phones.
Was the information you were able to get when you got a search warrant any different than that anybody could look at on a public site?
No, direct messages are private. It's just between the two users. Unless the person, displays the message, it's just between those two users.
So did the general public have access to that information you were able to obtain about gangs through social media search warrants and the like?
No.
I'll sustain the objection. Ms. Outlaw, I think we're in need of a break at this point in time. As I understand, I have it on good authority.
We get a break. The
ladies and
good
gentlemen, let's go
authority
ahead
break.
and take, recess until 11 o'clock. We'll come back, okay? All right.
All right, 158. They're back at 2:20. So we are 2 hours and 18 minutes into this stream, like my stream. And we're about 2 hours and 21 minutes into day 63. We already watched day 62, all the relevant parts. Like, look at this typing. Yeah, this is sped up. This is sped up.
Oh, okay.
All right, you may continue.
Thank you, Judge. And I keep wanting to call you Detective Gaither. What do I need to call you?
Just call me Gaither. Look here.
Okay.
Either one.
Not Ms. Gaither, Ms. Gaither.
Whatever you feel.
We were talking about when we left for lunch, the information.
Don't yet, don't.
I'm sorry. Freudian slip, my apologies, Freudian slip. We were talking before we left for break about social media information gathered through search warrants. How many social media accounts would you say you've had access to over the years during your time with the gang unit?
You mean looking at others or my own?
Where you gathered search warrants to look at social media accounts.
That sounded like a little giveaway there that she was just cozy cush sitting there scrolling social media. Sometimes it was someone that she was investigating. Other times she was just cooling, hanging out.
To help you learn more about anyone's participation in particular activities.
We started with the social media roughly 2011 or so. We really started getting in depth with it. So from 2011 to really when I retired in 2020, probably hundreds, honestly. It's a lot.
And was it from only one site, or did that
No.
information you had access to vary?
Oh yeah, it varied different sites. We've received information from Facebook, Instagram, Snapchat, was it Bumble or Bimble? Not familiar with the TikToks. That's new to me, but
Wait, did she say Bumble? Why? Why did she say Bumble? Look at Steele's face right now. I'm sure he's not making a face because of what she said, but it's pretty perfect.
you know, back then the MySpace and the Facebooks and Twitter were the popular ones.
All right. And how many cell phone extractions or data dumps have you had access to since you worked as a detective and officer in the gang unit?
That got to be several hundreds over my time.
Were those cell phone data extractions information that the general public had access to?
No,
Did they give you useful information in investigating gang activity here in Atlanta?
absolutely.
When people were arrested or detained for crimes in Atlanta, where is it that they're taken? For felonies, generally.
Generally, Fulton County Jail.
And are you able to, during your time at the Atlanta Police Department, were you able to have access to calls that were made from the Fulton County Jail?
Yes.
How were you able to get that access?
We would have to receive, obviously, permission from, I believe, the sheriff, whatever sheriff that is, or administrator of the jail. Once granted permission, we would have access to, what was it? Maybe Securus. I believe Securus was the name of the system that the jail used to allow inmates to make phone calls, and we had access to that.
Did you
system.
have to log into the system with your own personal password given to you by the administrator?
Yes.
Did the general public have access to that information that you gave?
No.
And what kind of information, if any at all, did you get from jail calls while working in the gang unit?
Jail calls were very important as well, especially the ones that were made really early on when a person was arrested.
Cases.
The foundation, I don't have any of these jail calls.
Oral, sir.
The calls that were made from intake, they're labeled as intake, and those are.
Objection, Your Honor. The individual cases, I object.
I overrule your objection, sir.
You can get
Can I continue your objection?
You may, sir.
The intake calls for us were the most raw and important ones, because that's when a person's, first get into the jail, they're calling whatever loved one, the person they want to talk to, and generally you get the most information from that.
Cases, sir.
She hasn't given any.
I'm gonna overrule the objection, sir.
All right. And what, if anything, did you do with the information you gathered from jail calls, social media, cell phone extractions, as it related to your role with the gang unit?
Objection, compound question. I'll stand as a form. You can rephrase mine.
What did you do with the information you gained from jail calls as they related to your role with the Atlanta Police Department and the gang unit?
We would definitely save them, download them to our computer, and add them to the investigative files.
Now, when you say add them to the investigative file, would that be the file on particular people or just the general file?
Well, if the person was in jail, it was obviously for a crime. So generally we would, during our investigations, we would make a file folder, and we would download whatever jail calls or social media, cell phone extractions, and put it either on a disk or a jump drive and add it to whatever investigative file as to memorialize information and keep it.
How many jail calls would you say you listened to, did you listen to while you were at the Atlanta Police Department and the gang unit?
I don't know. It's a lot. A lot.
Is it over 100?
Well over 100.
All right. Does it exceed 1,000?
Probably close to. It's a lot. I couldn't give you an exact number, but that was a very important tool that we used.
Wait, did he call her? Was there a sir mentioned? I missed it. That's a little funny. That is a little funny. And thank you, by the way, Steph. This whole thing is sad. So grateful for chat, my sunshine. Super shout out to the chat. Do you guys need a 60-second vent session? Do you need one? Because I love the chat. You guys, let's start one.
That you put in the file, what would you do with the file once you completed your investigation?
We would put it in the file cabinet.
Did you give it over to the DA's office after an arrest was made?
Oh, I'll stand the objection. You can rephrase.
Did you just leave it in the file cabinet?
No, if the case went further or, the DA's office wanted it, we would forward it to them or make a copy for them. It wasn't a secret file that we only kept if, the DA needed a lawyers, we would definitely give it to them.
Besides the difference in pay, what other differences existed between your role that you served as an officer in the gang unit and your role that you served as an investigator in the gang unit?
There's no difference.
So what was it that got you promoted? Got anybody promoted?
Take the test and you pass, you're promoted.
Did experience have anything to do with it? Like the time in the gang unit?
Well, you couldn't apply to be a detective. I believe you had to be on for, at the time, maybe 5 years, like 4 or 5 years. You had to be employed for the department before taking the test.
So as an officer with the gang unit, would you do any more or the same type work that you did as an officer, say, in patrol or with the 15, as far as investigations were concerned?
It was more closer to the 15 work. Patrol, I just erased that part of my life. I just wasn't doing that. But it was closer to 15 work rather than patrol.
Were there any particular parts of Atlanta that you had more interaction with as related to the other parts of Atlanta during your time with the gang unit? Did you focus or concentrate on any area at all?
One of the most crimes were zone 3, 1, and 4. So we did a lot of work in probably zone 3 was the most. It was really all over the city, but zone 3 and zone 1 and 4 were the hot zones for crime.
Did the information that you were able to gather during your time as a patrol officer and as a fit officer serve you in any way while you were at the gang unit?
Absolutely.
In what ways?
Just prior relationships that I built, talking to members of the community, people I arrested in the past. Just those relationships definitely help with information gathering.
Were you in plain clothes all the time during your gang unit tenure? Did you wear a uniform sometimes?
No, we very, very rarely were uniform. Maybe 2 or 3 times within a couple of weeks throughout my entire time there that we actually had to wear uniform, probably for a detail, but we were primarily plain clothes.
When you met with people in the community, did you make it known that you were a gang unit officer or detective during your time in the gang unit?
No, I think the ones that knew me, but I didn't display it like I'm a gang detective. They just knew me as G.
They call you what?
G.
G? How
I'm overruled the objection, sir.
much contact, how many self-identified gang members did you have contact with during your time in the gang unit? Just outside of arrests, just normal?
Are we confrontation clause 10 years?
I'm not asking for what anybody said.
Yeah, I'll overrule the objection, sir.
And you're not as far as a foundation for what we're doing.
Yes.
We're not doing anything.
Mr. Steele, please don't speak. Okay, don't speak your objection. Give me a basis and then I'll move on, okay?
Ask for what you're saying, specifically what the person tell you.
Okay, as part of foundation, I'm going to overrule your objection, sir.
So how much contact did you have with people who identified as gang
Start
members?
looking over. He said.
Throughout my tenure in gangs, I mean, hundreds. Not against the law.
What did you just say?
It's not against the law to be in a gang. So if that's what you're asking.
And how readily did self-identifying gang members interact with you after you got in the gang unit as opposed to while you were in FIT or on patrol?
FIT, I can't say I did much gang investigations, but once I was in gangs, it was often, I mean, just general conversation.
Did you ever gain information from self-identifying gang members about the gang that they identified with?
Yes.
How often were you privy to that kind of information?
I think once I became more seasoned as a detective and even an officer, when we would conduct interviews, whether it was gang members as victims or witnesses, I kind of made it a point to ask them questions regarding the gang because that was not my focus being in the gang unit. So it wasn't just about whatever incident or crime we were investigating at the time. If I knew them to have to be a gang member or an associate, I would definitely ask questions regarding the gang.
Is the information you gained during those interactions information that the general public had access to?
No.
While working with the gang unit, did you employ any standard protocol for identifying associates or members of gangs in Atlanta?
Yeah, we would kind of follow what the state of Georgia recognized as what a criminal street gang was.
And when you were looking at groups of people determining gang affiliation, was there any certain number that were affiliated with the group that you had to, for your purpose, meet before you identified a group as a gang?
The law, Your Honor.
I was thinking about the methods that she used.
I will the objection, sir.
You
Was
said
there-
a particular number?
Yes, before you identified a group as a gang. In other words, for APD purposes, did a gang have to consist of a certain number of people, or a
Yes.
group rather?
Yes.
What was that number?
3 or more persons.
And did those 3 or more people have to have any particular characteristics per APD standards to be identified as a gang?
Yes.
And what were some of those characteristics that they had to have?
APD standards are.
Your Honor, we can ask, Your Honor, about what laws they followed, but we are trying to establish the basis for this.
I'm over the objection, sir. Let me answer the question, ma'am.
Yes, sir.
What characteristics or what things did you look for in order to determine if a group that consisted of 3 or more people were a gang for APD purposes?
For APD purposes, we have a 6-point criteria that we used. I can try to remember it word for word, but it's been a little bit of time. If a person self-admits that they're a gang member, we would consider that as a factor. If we receive information from an unattested informant that the person is associated or a member of a gang, we use that. If a person identifies themselves by the style of clothing, monikers, hand signals, we use that. If a person frequents a particular neighborhood or area and associate with other identified gang members, we consider them a gang associate. Or if a person is arrested with other gang members and identifies
This is
themselves with the same
so-
monikers as that person, we take that into consideration. That might be
This
slightly
is
off,
so
but I
weird
think
that
that's
this
the
is a
general
Daubert hearing
definition.
in front of the
And when
jury.
you're talking about identifies and certain clothing, hand signals, are those characteristics that you all are looking for in groups or something different?
No, I mean, we definitely look for them when trying to identify gang members or associates. It's associated, in fact.
And did you consistently apply that protocol to make your decisions regarding classifying people as a gang member or a gang?
Yes.
How many cases involving gang activity would you say that you have been involved in since your time or during your time as a law enforcement officer?
We were talking about gang cases. We worked as a unit, but we did have our individual cases. So just involved with, I'm sure, well over 1,000.
And did the general public have access to the information that you amassed in those over 1,000 cases?
No.
Were you ever a member of the Georgia Gang Investigators Association?
I think I was.
And do you recall where it was that you obtained your 40 hours of gang training?
Uh,
That's why steel is seething.
maybe Savannah, Georgia. I know they had an annual conference down there.
Was that with?
GGI,
Okay, the Georgia Gang Investigators Association?
yes, them, and I believe APD may have put on a training. I believe Gwinnett County. I believe I've been to Las Vegas for a training.
The instructions from the judge are that you're going to hear fact testimony and expert
Vegas?
testimony.
Yes.
So
No,
they
it
don't
was a
really
couple of
know.
days.
They weren't instructed that she's not qualified yet.
That training was more about the national traditional gangs, street gangs in California, Los Angeles, New York. It really didn't pertain to much in Georgia.
Now, when you're talking about Georgia, would you explain for the jury what differences you saw between gangs in Atlanta and gangs that you experienced growing up?
Oh, sir.
You mind repeating that or repeating that?
Not at all. What was the difference between the gangs you saw in Georgia and the gangs you saw in England?
Initially, I didn't know it was gangs in Georgia. So once the more traditional national gangs came to Georgia, I mean, it really wasn't a difference. You saw some of the same characteristics. But when I first got here, it was more just neighborhood cliques. It wasn't, the gangs that you know and see on TV. That was not here. Well, I didn't see them here in Georgia.
Did you always use the Georgia law definition of a criminal street gang and criminal street gang activity when you made your cases while you worked in a gang?
Yes.
Also, Your Honor.
Overruled the objection, sir.
When you obtained information about a person's alleged gang involvement, did you do anything beyond that bit of information? And I'll give you an example. Someone says they're in a gang. Do you look any further to get any more information, or do you just stop right there?
No, I mean, if someone admits that they're in a gang, I mean, I don't take what anybody says on face value.
What else do you look for?
Yeah, well, social media, look for previous police reports or FIFs, which are field contact interviews, where it's basically like a report, but it's not an arrest report. It's just saying the police had contact with this particular person, and it's just short details or narrative of what the contact was. We do get a lot of information from that, and the gang unit did a lot of FIFs just to memorialize whatever information was given during that interaction.
Is that information the general public has access to?
FIFs?
Yes.
I don't know if they can do an open records request for it, but I don't believe so.
Doing open records.
Oh, okay.
Probably not in Fulton County, even if they
And
were
would that
supposed to.
information, lead you to any kind of better understanding of gang culture in Atlanta?
Getting information from that particular person?
Yes.
Yes.
What about if someone just told you that another person was involved in a gang? Did you stop right there, or did you do anything else to
Right.
corroborate what they were saying?
Yeah, no, I mean, it's just unattested information at that time. I mean, we do document it, but if someone tells me somebody else is in a gang, I definitely want to verify it on my own. Try to get possibly social media, pull up, like I said, previous arrests and interactions with police, just to try to confirm the information that they're saying.
And do you even have a number for the number of people you've interacted with who've given you information you consider reliable about reliable gang intelligence?
From gang members or just
Non-gang,
anyone?
anybody.
I can't put a number on this. It's a lot.
So the reason we're not looking at Detective or former Detective Gaither is Love came in and the day before what we're watching right now and said, Your Honor, we can't show this witness. There's security concerns and she doesn't have the protection of the badge anymore. Right? We heard that yesterday. And since then, shout out to Casper in the chat. Casper has given us great context here. Like, Lakia Gaither, her pictures are online. She has an IMDb profile. She's been on First 48. She currently works as a security guard. Well, maybe not currently, but at least in 2020, 2021, 2022-ish. Maybe she's still doing it, but she was at least working as a security guard between back then and now. But somehow she doesn't feel secure. She doesn't have the protection of the badge. If you're so scared, how are you employed as a security guard? But Judge Glanville was like, normally I need to have a Rule 22 hearing to not show a witness. But all right, I'm just going to grant it. So they asked, so the state asked, and it was just granted very quickly in a manner that typically it's not just granted on a whim like that, just on an ask. And hold on, I'm not saying that like witnesses should always be shown. I get that there's circumstances where there's a reason not to show witnesses. But here it was just kind of like, raised my hand and asked, and the judge was just like, well, I'm supposed to have a hearing, but okay.
And have you ever either formally or informally given any instruction on gang activity or criminal street gangs? Either.
I'll sustain this form. You can rephrase.
Have you ever trained any other officers or any other persons on how to recognize criminal street gangs?
Informally, because I was in the gang unit for so long, I've taught newer investigators, and I went back to the unit as a supervisor. So I've given training in that aspect as well about gangs to newer investigators.
And what kind of training would you provide them?
Just a general identifiers to look for, had them really read up on the law. I mean, I can't tell you how to do your job, but I'll lead you to the water. And, it's gang.
Glanville
gang
does make
investigations
a
really up to the
couple,
that
a few
investigators wanna learn
CYA
and
moves,
understand.
so that makes
I would
sense
definitely provide the
too.
information, but it's up to them if they want to learn it.
And did you seek to increase your knowledge and awareness of gangs and gang activity during your time?
As she's in the interview
Initially, I
videos.
wanted to do as much training as I could, but once you get involved with investigations, it just kind of consumes all of your time. And training was, I was getting my on-the-job training. I wasn't going into the classroom learning.
I'm going to show you what has been provided to the defense and what has also been used as State's Exhibit 98 Bravo Bravo. And I'll give them about no one. Okay. Oh, okay. So, check. I'll show you what I mark as 99 Bravo Bravo.
Okay.
You recognize State's Exhibit 99 Bravo Bravo?
Yep.
How do you recognize it?
It's my police resume.
Okay. Is that a fair and accurate copy of your resume detailing your
Yes.
experience with law enforcement?
Yes.
Your Honor, the state tender states exhibit 99, Bravo, is evidence.
I object to this evidence, Your Honor. Do you know what this is? CB.
I see. For the purposes of determining foundation, do you have any objections to that?
But it was not tendered as that. It's in the evidence. Okay. Tendered as.
I tell you, I'm going to admit it for the purposes of a foundation and only that. Okay.
Thank you,
All
Judge.
right.
Have you received any recognition during your time? Did you receive recognition for your work while you were in the game from any?
It's sped up.
Yes.
Would you please tell the jury about those?
I remember maybe it was, thank you. 2013, I was the Atlanta Police Department's Officer of the Year. 2014, I was Atlanta Police Department's Investigator of the Year. 2016, I was Atlanta Police Department Crime Fighter of the Year. And just throughout my career, you get the Officers of the Month and Investigator of the Month. But those
Okay,
are the,
if you
the main
okay,
three.
pretend we
And
didn't have
when
any
that was
context from Casper for the chat. Try to like erase that from your memory like the jury said they could do with Woody's testimony. If you heard everything that we just heard from Gaither, you're sitting on the jury, and then you heard she got these awards 3 years in a row, what would you be thinking? What would you be thinking?
Tell the difference between the Officer of the Month, Investigator of the Month, or Officer of the Year. What's the difference between the two?
Well, the one is for the month, and the yearly.
Okay.
No, the yearly ones are department wide, just your cumulative work for the entire year. They like to recognize who they want to recognize.
Have you ever testified in trials in Fulton County?
I have.
Have you ever testified in other counties at
Yes.
trial? Have you ever testified and been qualified as a gang expert in Fulton County?
Yes.
Have you been qualified as an expert in any other county besides Fulton County?
Yes.
What county?
DeKalb County
Do
and
you-
Clayton. I'm sorry,
Please let me-
with Clayton County as well.
Do you know how many times that you have been qualified as an expert overall?
I didn't do a lot of trials, so I'll say roughly 5 to 10, somewhere in there.
And during your time with the Atlanta Police,
You're the star APD detective. You've had, since 2007, in some capacity, you've been working with APD. You started doing your training, 2012, I think she said? That she retires in 2020. By this time, because this is 2024 when she's giving this testimony, she's only sat as an expert witness in 5 to 10 trials.
department, were you deputized by Fulton County as well?
Yes.
And what did that mean?
Being deputized basically gives you police powers throughout the entire state of Georgia.
And was every gang unit investigator or officer also deputized by the Fulton County Sheriff?
No.
So how did you get that designation?
I don't know. Maybe our investigations kind of went outside of the county of Fulton, so we asked and got permission from the sheriff, and the sheriff deputized us.
How often did your investigations take you outside Fulton County?
It varied. I mean, quite a few times.
And did the information you gathered when you did investigate matters outside of Fulton County at all contribute to your gang intelligence knowledge base, if you will?
Yes, they have.
Did you get information during those investigations that was not accessible to the general public?
Yes.
Just one moment. Your Honor, at this time, the state tenders Ms. Gaither as an expert in the area of criminal street gang investigation and identification. Just one moment. And criminal street gang.
What other witness? Mr. Steele? Anyone else? Let's see. Ms. Weinstein?
Okay, wait. She said 5 to 10 times, right? She said she works in multiple counties. When someone says 5 to 10, she's not really sure. If it was on the lower end, if it was 5, and Whitaker lets them call the other 2 gang experts, there will be as much gang expert testimony in this trial as Gaither gave expert gang testimony in her whole career, her decorated, for whatever reason, career.
Your Honor.
Mr. Matthews,
No questions, Your Honor.
Ms. D. Williams, Mr. Sharp. Do you wish to voir dire the witness? Yes?
No, sir.
Okay, all right. I missed anybody? Huh? Mr. Gardner, apologize, sir. Do you wish to voir dire the witness, sir? What was the designation you'd like to have her, hold on one second. Okay, hearing no objection, the court will designate Ms. Gaither as an expert in the criminal street gangs and investigation and identification.
And I'm assuming they don't object because
Said that.
wrecking Gaither is better for their case than not having her up there to be wrecked.
How many criminal street gangs you became aware of during your time in the city of Atlanta while you were working with the gang? How many did you recognize? You didn't have enough.
I don't. There were quite a few what we call hybrid gangs, which was like neighborhood gangs. And we slowly began to see a lot of the neighborhood gangs either fade away or migrate to the traditional national gangs.
And what is the difference when you say hybrid gangs and neighborhood gangs between that and traditional or national gangs, as you call it?
The hybrid gangs were more loosely formed. It wasn't a lot of structure as far as ranking and bylaws that they followed. The traditional gangs had more of those characteristics. The hybrid gangs were just initially neighborhood guys just committing crimes, really. But the national traditional gangs had more structure to them.
And May, we'll get to this
What distinguished a group of people standing around wearing
when
the same
she's
colors
released
and saying,
here.
you know,
She's still
you
under
need someone
subpoena
inside
by the
from
state
another
and
people
still
that you
motions
classify
or
as a
ask the
criminal.
judge to extend that subpoena so he
if
can
both
call her
sides
back
are,
too. She is on his
standing
witness
around
list.
claiming a particular gang and committing criminal activity, then they're considered a gang.
And is it necessary that the people who are in the group you classified as a gang, that they be committing criminal street gang activity in order to classify the group itself as a gang?
Sir,
The law comes from the court.
I'm talking about her and the way that she carried out her investigation, John.
Under Olson versus State, decided 6 weeks ago, it's irrelevant with APD policy.
I didn't recognize policy, Your Honor, because during investigation.
I'm gonna overrule your objection, sir.
You mind repeating that, please?
Steph JK sniping with the gifted memberships in the chat. I gotta open YouTube and see who turned green.
As a gang, that they be committing criminal street gang activity in order for you to classify the group itself as a gang.
No, I mean, it's not against the law to be in a gang. It's just when that you're in a gang and you're committing crimes in furtherance of the gang that it becomes illegal. So, no, I guess no is the answer.
Oh my god, it actually went to Dapot. Look at that.
When did you first, what were the gangs that you first noticed when you did begin to recognize?
That is
gang
awesome.
activity in the city of Atlanta?
You want the hybrid gangs or the
The
hybrid?
first ones that you noticed.
Some of the more well-known ones was CRG, which is Campbellton Road Gangsters. They were operating in Zone 4. We did see ROC, which was from Cleveland Avenue, 30 Deep, which operated in Mechanicsville.
Yeah, what are we hybridizing
Red
here,
Cartel,
guys?
which was from Cleveland Avenue as well. Jack City, which was Jack City Boys, which was I believe that was Thomasville neighborhood of Atlanta, excuse me. MDC, which is Most Dangerous Clique. They were out of Zone 1. Just off the top of my head, I think those are some of the larger ones.
What year did you start noticing the city size of those particular gangs?
Maybe 2008, 9, but I thought they were just neighborhood cliques. I didn't recognize them as, oh, you guys are a gang. So maybe 2008, 2009, once I got to the gang unit. And that was the shift of focus.
And what happened to cause your focus to shift on looking into these groups further? Besides your getting promoted or
Transferred. I guess just to understand the law and what the law considered a gang to be. It just kind of transformed into the work that I did and how I looked into my investigations.
What type of crimes did you see being committed by this group?
All types of crimes, narcotic sales. Like I said, the big thing then was the smash and grab robberies and burglaries. We had murders that we assisted with, the homicide unit with, aggravated assault shootings. It was everything from A to Z. Fights in schools, vandalism, spray painting buildings and stuff.
And property crimes, did you ever see property crimes being committed by gang members?
Yes, that's what smash. I'm sorry.
Ask and answer.
I never been to property.
I don't think she has. I'm gonna overrule the objection, sir.
So Detective
Yes,
Dennis
property
was
crime
like
would be
day
a smash and grab,
71.
burglary. We also saw a lot of auto thefts, which would be considered a property crime. Vandalism.
I just looked at that recently because I thought about restreaming that.
Gang graffiti. That
He
would
was,
be
I think,
considered a
two
property
days.
crime.
Prior to your getting transferred to the gang unit,
Mm-hmm.
if there's, say, a drive-by shooting at a house, no one's hit or hurt, generally speaking, what happens to that type of case? Is it investigated further, generally speaking, before you got into the gang unit?
Relevance and also vague, which one are we talking about?
I'll sustain this vague.
Thank you.
We can rephrase.
Thank you. Was there anything that you noticed about property crimes that did not involve a person being hit that caused the Atlanta Police Department to treat those crimes differently after the gang unit began investigating gangs?
Yes. After a while, we noticed, I want to say it was maybe 2015, 2014, that damage to property crimes were not being investigated. So we would get some drive-by shootings at residences, and if no one was, injured during that shooting, a police report would be generated by the responding officer, and it would be classified as a damage to property. Whether a window was shattered or a car window or damage to a home or a door, it would be classified as a damage to property. Well, those reports are generated, they go to central records, and that was it. It was no further investigation. So once we discovered that was occurring, we basically went back some months and found quite a few damage to property reports that were, what we later found out were related and just hadn't been investigated.
Could you do me a favor? Could you speak directly in the
I'm sorry.
and use your outside voice so we can.
This one?
Yeah, that one. That's
Okay.
it, so we can hear you a little better. Thank you.
Yep. Yeah, so we essentially went back to investigate a lot of these damage to property reports, which we found were related to an ongoing bigger investigation, which changed how Atlanta police categorized damage to property reports.
Did those damage to property reports mainly involve shootings at residences where no one was actually hit?
Yes, the ones that we were focused on, where it was shots fired calls or residences shot. If there wasn't a person necessarily like standing in the window or standing on the porch, and it was just, the property was damaged, that's what the crime would be a property damage to property, and it wasn't being investigated.
At any point during your time with the Atlanta Police Department, did you become familiar with a group calling itself Young Limelight or YSL?
Yes.
Do you recall
Here we
when it
go.
was that you became aware of the existence of such a group?
Roughly 2013.
And what put that group on your radar?
Well, the group was essentially already on the radar from its affiliation with Raised on Cleveland Rock Crew. And we began to see the members who we had previously identified as members of Rock Crew were now claiming YSL Young Slime Life. So, they had already been on the radar. It's just we hadn't heard of the name Young Slime Life before.
And were the members that you became aware of only from Rock Crew, or were there any other groups that you saw these members had prior affiliations with?
Yeah, we saw early on members from Red Cartel were now claiming to be Young Slime Life. We saw, I believe it was Block 125 or 125 Block, something like that. They were associating themselves with Young Slime Life. And later on, years later, we began to see members of 30 Deep were now claiming to be Young Slime Life. So, and then the traditional gang of Sex Money Murder began associating, or the association connected with Young Slime Life.
When you first became aware of the existence of a group called Young Slime Life or YSL, did you find any criminal activity being committed by members of that, or did you just hear generally of the group itself?
Yeah, Rock Crew early on and Young Slime Life, we investigated numerous crimes from robberies to auto thefts. Rock Crew were responsible for quite a few ATM thefts in the city, smash and grab ATM thefts. So those were the crimes early on that were associated with them.
And based on the training, experience, intelligence, and knowledge that you gained during your time at the Atlanta Police Department's gang unit, do you classify Young Slime Life or YSL as a criminal street gang?
Yes.
Did you identify persons who were either members of or associated with Young Slime Life? during your time with the Atlanta Police Department?
Yes.
How did you identify those persons as being affiliated with or members of YSL?
Refer back to the 6 points that I was talking about APD on what we look for. Also, the main one was admission or self-representation.
And were there particular victims that were being targeted in those robberies you mentioned, or no particular?
I
Who were they robbing?
don't think it was a particular group of persons. Whoever had something that they wanted. I mean, wasn't any boundaries on who.
Was it uncommon to see robberies of drug dealers by gang members?
No, it wasn't uncommon.
How often would you see that?
Happened all the time, but we didn't get a lot of reports from the drug dealer to say they stole my drugs and money. So, but sometimes we did.
And when you got those, did you investigate the robbery itself?
Absolutely.
And did you, even though the victim is a drug dealer, did you try and prosecute the person who robbed it?
Absolutely.
Did you identify specific people that, based on your training, experience, knowledge, and background, were members of YSL?
Did I investigate?
Did you identify?
Identify, I'm
during
sorry.
your time?
You may, sir. Thank you, sir.
Side back. And they don't really turn to show the sidebars or what they're doing up there because I don't think they want to risk panning and showing the jury. I don't know how long this goes on.
Jeffrey.
Would you tell the jury which ones?
There we go.
Ms. Gaither, during your time in the Atlanta Police Department game, did you identify any of the people in the courtroom today as members of the criminal street gang, Young Slime Life or YSL?
Yes.
Would you tell the jury which ones?
Initially, Mr. Jackson, Jackson of Stillwell was claiming 30 deep, but he migrated to Young Slime.
You may go ahead.
He eventually migrated to Young Slime Life. When I first met Mr. Williams, incident occurred, I want to say it was maybe 2012, 11. That is when.
No, just.
Okay.
Just
I apologize.
Yes, no problem.
Mr. Williams and Mr. Jackson was Stillwell.
And by Mr. Williams, what was his name?
Jeffrey.
And that was, is that the extent of the persons during your time at Atlanta Police Department gang that you were able to identify as it relates to people in this courtroom as members of the criminal street gang YSL?
Objection has been answered.
No.
Objection, sir.
Go ahead.
And later on, Mr. Kendricks from Investigations.
And is that Diamante?
Yes.
Did you personally have an opportunity to have personal interactions with either or all of these individuals during your time with the gang at the Atlanta Police Department?
Two of the three, Mr. Kendricks and Mr. Jackson.
And by Jackson, are we talking Shannon Stillwell?
Yes, Shannon Stillwell.
And would you just identify for the record where each of those persons is situated in the courtroom by an article of clothing or?
Yes. Mr. Kendricks.
So,
And I was stipulating Mr. Kendrick sitting there.
don't worry about it, don't worry about it. Yes, thank you.
So, yeah, so the record will reflect that these are individuals that the witness identified.
It's y'all.
Thank you. Your Honor, this is the point at which, let me also ask you, did you ever have any interactions with Walter Murphy?
Yes.
Did you go by the name DK? Is that the same Walter Murphy we're talking about?
Yes.
Remember,
Did
Walter
you
Murphy is
identify Walter
DK.
Murphy as a member of the criminal street gang, Young Slime Life or YSL?
Yes.
And what about Trontavia Stevens, who may have gone by Tick or Slug? Did you ever have any opportunity to interact with him?
Yes.
And did you, based on your knowledge, training, experience, and background, determine whether or not he was a member of the criminal
He
street gang?
being who? Who, madam?
Trontavia
Walter
Stevens,
Murphy.
Yes.
Oh, Slug.
as a member of the criminal street gang, Young Slime?
Yes.
So this is where, and we might, not this day, but some of the upcoming days with Gaither, because Gaither was on the stand for like 6 or 7 days. Some of it is just hours of interviews or phone calls with Walter Murphy or DK, and then Trontavia Stevens, Slug, who also took a plea. Like, neither of these people are on trial. and Gaither is on the stand talking about them for like 2 days. So we might skip some of that stuff, especially since I do plan to look at DK's testimony, which we'll see some of that same stuff. But yeah, just to conceptualize, this trial we're on like day 117. Monday will be day 118, I think, maybe 119. But you've got 2 days of testimony about an incident that none of these 6 co-defendants are involved in, just because of that overarching gang conspiracy theme.
What about Kelvin Treadwell or OG Denver?
Yes,
He's also a member of gang YSL.
yes,
And what about Antonio Sledge or Moulton? Is he also a member
yes,
of YSL?
yes, ma'am.
Quindarius Zachary or Lil Diddy? Is he also a member, based on your training, knowledge, and experience, of the gang called YSL or Young's Limelight?
Yes,
Jamekion Garland, is he also a member of the gang or criminal street gang called Young's Limelight or YSL?
yes, as well as another one.
When you, as well as
Another gang as well.
what is the other gang?
30 deep.
What about Demise McMullen or Nard? Did you have an opportunity to classify or determine whether he was in a gang?
Yes, YSL.
Kenneth Coates or Rudy?
Yes, YSL as well as 30 deep.
Is YSL the only gang affiliation that you determined for Shannon Stillwell, Shannon Jackson?
I sustain the objection.
Thank you. And Your Honor, at this point, the state is getting to this witness as a fact.
Okay. Ladies and gentlemen, given that one of your members has to leave, it might be just for an appointment that we already talked about. It might just be better if we just broke and recess for the day. I'd let you just have lunch and just go ahead on and enjoy your afternoon. So what I'd like to do is just recess you all for the day. 1 second. All right, ladies and gentlemen, please be seated. Our jury has left us.
And now we're going to get some spicy steel. A little spicy steel.
All right, counsel. So tomorrow, 12:30, we'll pick up where we left off, and we'll just continue and see how far we get, and we can then talk about next week, the week of the 22nd. Okay. All right. Anything I need to take up now?
You understand at 12 o'clock, report time to start at 12:30?
For tomorrow?
Okay.
Remember, Ms. Love, I got other things I got to do. I got Veterans Court tomorrow. Okay, I told you. So, but I will be down here and available. I'll come down for 12:30 in case we need to take up anything. So I would ask that you all would be here for 12:30. So if you do need to take up anything, we'll have that 30 minutes to do so. Okay. All right. Is there anything else I need to take up at this point in time with you all, sir, Mr. Steele?
There will be, and I assume it's just, sorry, I assume it's the targeted objections, but Walter Murphy's original interview is not redacted. The state gave us a transcript that is not usable. And the only thing redacted is the exculpatory statement when Mr. Walter Murphy, which you excluded already, said that you're not going to get killed for this, but it doesn't involve Jeffrey Williams.
But remember, I told you yesterday that you were welcome, but you have a differing opinion than Mr. Short does, and you may get into that particular issue.
I do, and I appreciate it.
And I haven't forgot, and I said that yesterday. So
I appreciate that. It's a different issue. The state only redacted Walter Murphy saying, yeah, I was scared. I could be scared. I could be killed. That has nothing to do with Jeffrey Williams. The only thing that they redacted is this has nothing to do with Jeffrey Williams. So the whole thing should be out because under the case law you have, which I have to refresh my memory, just remember it was an M case, but since it doesn't apply to any guilty consciousness, and Mr. Murphy did cooperate with the state again, a couple months later in August and February, and then testified that July 17th should not be discussed at all. In addition to that, I was told that the prosecutor questioning Detective Gaither is going to ask questions like, did you ask Mr. Murphy whether he had a gun, or whether Mr. Murphy was around this person? Those are hearsay. It doesn't matter what the detective asks. It's the answer of Mr. Murphy that would be inconsistent if it is inconsistent. So I just don't want to waste the time. That's what I was trying to do this morning. It's just a lot of time consumption. So I just want to alert you that I'm objecting again to everything being played the way I think the state is trying to play it, but that July 15, 2015 recorded interview should not, in my opinion, it has no relevance except he was threatened, he felt threatened rather, and then he said he was not due to Jeffrey. So why is that coming in when he cooperated the next 2 times, which is what the case law says? That's my objection.
all right, state, what do you have to say?
Response to that. You addressed this yesterday, Your Honor, and it was relating to specifically the search. Mr. Steele does not quite have it right as the court ruled. It was the search of Jeffrey Williams' home that the court excluded. That was the only thing that the court told us that we should not and could not get into. The court has never, ever ruled, as Mr. Steele may have mistakenly thought, and said that the court or the state could not get into the points with which Ms. Hilton confronted Mr. Murphy as it related to the fears he expressed regarding telling police officers what happened. As a matter of fact, on the stand, Mr. Murphy testified that he didn't remember what he said in the July 15th interview in 2015, but he knows the only thing he was afraid of was going to jail because he had been false flagging as a blood. He made that assertion numerous times on the record, and that has never been the subject of a point of contention that the court has addressed that we would not be allowed to get into, because the court, as a matter of fact, looked at it, analyzing it under a party's bias, a witness's bias, or motive, or leaning towards a particular party. And I think that statute is 24-6-6-22, I believe we brought it to the court.
Yes.
I'll look it up and make certain. But we definitely confronted Mr. Murphy with those statements. He says, I could get killed just by being here. I could get killed for looking at this video. You all pulled up. He flatly denied that. He said, when you all pulled up and that officer pulled up his mask, that alone could get me killed. Throughout his interview in July of 2015, he talked about the fact that he could get killed because he was cooperating with the police. We never said that he was talking or pointing to Jeffrey Williams. So that assertion is actually kind of confusing an issue that is not a real issue. We're not trying to say that Jeffrey Williams threatened Walter Murphy. We're saying that Walter Murphy had a reason for acting the way that he did, and that the jury is entitled to see his asserted reasons that he then denied on the stand in the context of the reasons being stated.
All right.
And it's not 24-6-22. So 622, 17. 622 and one other statute. Just one more.
622, what, 24 dash?
24-6-622.
Okay.
And we argued this very point 2 weeks ago when we talked about other redactions, and the court ruled that we were allowed to get into this because it was a matter that he.
Yeah, you just can't talk about just general fear. It has to be related to one of those
And he
different.
talks about it in the.
All right, I did rule upon that already. All right, anything else, sir?
I filed a motion in limine. We had the conversations, we had all the cases. According to read them beforehand, I gave you all the 8 cases, I believe. And then the state asked one question. It was Ms. Hilton, the Honorable Ms. Hilton. He said that he didn't remember saying that. Asked another question about fear. I asked approach. You said, move on. You sustained the objection. I don't know how it's now going to be played, and I'm objecting to it. The court has ruled, and it is character evidence, and they took out. The matter is bad enough putting it in, but the state has redacted. I'm objecting. The only part, after he said, I could get killed for this, he said, but this has nothing to do with Jeffrey. I don't know how. Somehow that's the only part that is redacted. In addition, the state did not redact and take out all of the information about the search. And I've said it now 4 times, and I will. I'm putting everyone on notice. And I'm not saying you're going to grant it, because I heard what you said earlier. You're not going to grant mistrial. But this is out of control. This is an out of control part by the state. They constantly are ignoring the court's rulings. So I'm objecting. I put it on the record now, and then whatever happens tomorrow happens. I said you could deny it. And then
Well, I hope that it won't come up. It won't come up because you do need to trim out that, and I trim out those particular things about the search of Mr. Williams' home. Well then, here's the thing. Why don't you all get together and make sure that it's done and you see it.
So Mr. Steele and I have had a number of conversations about taking out the part of the search.
Okay, let's break it down.
So the search of the.
Has the issue involving Mr. Williams' home been taken out?
So yes.
Yes or no?
Yes, but the version that we're going to use is very similar to what we saw yesterday. So what the state intends to do, which is the transcript we sent over this morning, is the highlighted area, which is from 2 minutes, 2:49 p.m. and 51 seconds to 2:49 p.m. and 51 seconds to 2:50 p.m. and 11 seconds is the area in which Ms. Gaither talks to Walter about the search. That is out. We've highlighted that area. We've redacted it. We will redact it by muting that portion of the interview. The only other part that Mr. Steele is talking about is what we discussed yesterday, which is the mentioning that Duke, which is a co-conspirator, was at the house at the time of the search. When you rule that could come in, that Duke was at the house, not that can't come in. So the only thing about the search that is there in the July 2015 interview, so I want to be real clear, is that Duke was present. Now, if we need to take out the word search, we can take out the word search, but that Duke was present at Mr. Williams' home on July 15th when DK was arrested is very relevant because that's another co-conspirator who was at the house at the time in which another co-conspirator, Walter Murphy, was arrested.
Well, take out the word search.
So we can take out the word
Take out
search.
Walter Murphy being in the house, Duke being in the house. Yes, it would be relevant. So, all right. What else is now? Are you going to include back in what Mr. Steele said about the exculpatory portion of him, Walter Murphy saying, but this has nothing to do with Jeffrey?
That's not exclude. I don't know what Mr. Steele's referencing, so I would need to know what
Is it in
time
the
stamp.
tape?
I need to know which tape he's referencing, because the only thing that the state is redacting from the July 2015 interview is 2:49 p.m. and 51 seconds to 2 p.m. and 2:50 p.m. and 11 seconds.
So is
So
that-
outside of that, the state does not intend to redact anything else.
So is that in?
Yes.
So the only thing
based
that's
on
being
this.
redacted is the 2:49 to 2:50 and 11 seconds?
Yes, and then we're gonna find this one word search by Duke's name.
We are definitely taking that one word out. Yeah.
So I need to find where that is in this transcript. But outside of that, everything else is in.
Can you caucus or gather with Mr. Steele and just make sure that that is done, please?
Yes.
All right, Mr. Steele, you're gonna give it.
And the court also ordered, Mr. Richard, my motion, the state actually conceded it, that they would not be getting in that same day, that there was a search of a studio, a record studio. There's nothing to do with Mr. Williams. There's nothing to do.
I don't recall that. Was that part of your?
Motion, yes, and you ruling, and I would have to ask that.
Well, no, here's the thing. I don't think your motion limiting Williams number 50 has that particularity in it.
It was before this. We did it weeks ago. I raised this issue weeks ago.
Can you tell me what, can you tell me what motion was in, sir? I mean, I'm not saying you did.
I'm not challenging.
No. I'm just saying, can you tell me what?
Can I sit down for a second?
Yes, absolutely.
All right, so this is winding down.
And it's sending me notes.
Records, I'm not.
We don't have, we're waiting for this video to see.
Yeah, I know. Mr. Steele, you want to check your records? 'Cause I'm not to say that I have the best memory, but I don't recall the studio.
Say it offline.
If you find it, send us a group email about that. That'd be fine. Okay. All right. Anybody else? Okay. We're in recess until tomorrow. If you could be here for 12:30, I'll take up anything.
Okay, so that was the end of day 63. Day 64 is also a half day. It's really short. We aren't going to watch most of it. There's still recesses in it. In the beginning of the day, they have a bunch of sidebars. You can see how much they're at the desk. Thug is waiting. They're all at the bench. And then they end up asking Gaither more about the timeline of the creation of YSL and the initial beef with Birdman and ABG with YSL. That Gaither says that started back in 2014. Then they finally start talking about the 2015 murder of Donovan Thomas. And Gaither talks about, he was a high-ranking blood member in the state of Georgia, talking about Donovan Thomas, and that the theory is Thug commissioned his murder. But then she ends up giving some testimony that the beef actually started because of Woody and Shell Kell, who is Donovan Thomas's stepbrother, half-brother. And that's why this war between If Gang and YSL is like really ramping up and kicking off in 2015. Remember, Shell Kell is not on the state's witness list at all. But what I really wanted to jump to from this day, because that's pretty much a summary of it, there is this part where they talk about the taunting rival gangs. And they talk about references to the artist Future, a collaboration that Young Thug did with Future. And there's a bird and then a serpent, and that's obviously gang imagery. But the point is Love is looking for something from 2020 and beyond to say that there's still this gang rivalry and gang criminal acts going on in 2020, which would be within the statute of limitations, even if this Donovan Thomas murder doesn't stick. We'll watch this little part. We're not going to watch much of this day, and then we'll jump to the next day.
How long did this investigation into the conflict between Young Limelight and If Gang last?
And I retired in 2020 and it was still going on.
What did you say, the last part?
I retired in 2020 and the conflict was still occurring at that time.
What were you able to see personally that caused you to say that the conflict was still going on?
Shootings and incident.
I'll sustain as a form. Rephrase, please.
What were your personal observations that allowed you to believe that there was more to investigate between as to the conflict between the gang and YSL?
In 2020, up until 2020,
Yes.
there were still investigations involving different members from both sides, shooting at each other. There were fights within the jail.
Not personal observations. I object. You just said admonition.
I'm overrule the objection. I think that's what she's testifying to now, so I'm overrule the objection.
That's my answer.
And I'm going to show you, was there also, was there anything placed on social media that would have referenced that conflict that you saw?
I do remember seeing an album cover. There was an album cover of Mr. Williams with reference to bird gang with a snake going through the eyes and the head of the bird, which we knew represented
Objections, what they do.
what I knew.
I sustain objections to form. You can rephrase.
The information that you knew about the album cover that you were referencing,
Yes,
how,
the question.
Overrule, sir.
what information informed you about the album cover that you were looking at when you say the information I knew?
Based upon previous police reports and interviews of, the police, we knew of the conflict going on between the two groups. The album cover was released to the general public. It just looked like, a snake with a bird going through, but there was significance to us and what we knew regarding the two groups, that it was a form of disrespect to If Gang, ABG, Bird Gang.
And I'm going to show you what has been marked and already admitted as Defendant's Exhibit 70. If you'll look on your screen to your left or over your right shoulder, are you familiar with, have you seen the exhibit that's been admitted as Defendant Williams Exhibit 7?
Yes, I've seen it before.
And how similar or dissimilar is that exhibit to what you were just describing?
Looks like the same image.
You got to speak to that microphone.
Appears to be the same image.
Thank you. And what was it, help the jury or help us to understand, when you said that there was a snake going through a bird, is that what you said?
The narrative.
What did you say?
I stand the objection.
What did you say that this image was?
Objection, ask and answer.
I stand the objection.
Objection cumulative to prior testimony.
Overrule.
Are you able to take the pointer stick above the eagle behind you and just trace the outline of what you said is a snake?
This green and black item here. From here going up.
No, it's crazy because at festivals and rocker themed things, metal, a lot of the jewelry is snakes, skulls, birds with claws. What does that really mean just because it's on an album cover? Is it just because it's a rap artist? A rap label? 2 rappers?
Out to the head of the snake here.
And is the snake alive or dead?
Objection.
Basis.
Speculation.
Overrule.
Looks to be alive and well.
What about the bird? Would you trace the image of the bird?
In the rear of it to here, around to the beak. This would be the eye area.
Now, is the bird alive or dead?
Objection.
Basis.
Best evidence.
Overruled.
It appears to be decayed, dead.
Okay, thank you. Now, the snake that we just saw, was there any significance to its color in your investigation into that conflict that you described?
YSL members and associates identified with the color green, which represented Islam.
You talked about Rich Homie Quan. Did he do music as well?
Yes.
And did you know him at some point to do music with the defendant Jeffrey Williams?
Yes.
Was that prior to or before October 2014?
He's wearing
I believe
green
it was
right
roughly
now.
around the same time.
Overt act, intrinsic
Definitely
act.
2014. Not sure exact date.
Was it, so is that before January 10th, 2015?
Yes.
Okay. Did you ever notice a parting ways between those two?
Objection, you're said. Confrontation clause, speculation.
Did you?
Beyond the scope
I
of
can
your
rephrase.
knowledge.
Overruled as to all your basis of objection, Mr. Steele.
Did you ever notice a parting of ways between Rich Homie Quan and defendant Jeffrey Willis?
Based on the question, overruled.
Yes,
At what time?
maybe mid 2015. Spring, summer.
Thank you, Black Butterfly. This was Thug and Future's collaboration, The Snake and Eagle, because
What did
Future
you
has
see
the free bands,
personally
the
that
bird,
reflected that parting of ways?
and they had collaborated. And Love is trying to establish this through Gaither as some type of subliminal gang activity
Overruled the objection.
through 2020.
I personally observed any signs of the breakup.
The parting of ways. Did you ever see them?
Objection to witness not be allowed to answer the question.
Let her finish answering the question, Ms. Lynn.
Sure. You need to be clear then.
Objection to the question.
Overruled.
Myself and my unit, we were obviously monitoring both sides, the parties, including media outlets that made it known of.
That would be hearsay. I would object to media outlets being.
And
I'll sustain the objection.
we're talking about what?
Objection to speaking.
She's responding to me, Mr. Steele.
Objection to speaking again.
She's responding to me. Overruled. Sit down, please.
The witness is testifying about what she relied on.
What you elicited is speculation. So I'll sustain that, but you can rephrase it.
Did you ever see the two perform again after that time together?
Never. Sorry. No
Your
foundation.
Honor,
Overruled, sir.
did you ever see defendant Jeffrey Williams perform with Rich Homie Quan after that time?
No, I didn't.
Ian, I was gonna say you gotta
When
iron
you
your
spoke
shirt on
about,
1.5
social
speed.
media, were the social media posts that you saw always obvious messages to someone else?
I sustain the question.
Was it always apparent, the meaning behind what you were reading?
No objection.
I sustain the question.
I'll rephrase. Have you heard?
Starting to look like
references
whack-a-mole over there.
Have you heard references in YSL songs released by members of YSL, to persons who were a member of IFGAN after the death of Diamond House?
That would be hearsay. It's too late.
Your Honor, if she herself has heard it and can speak
Oh,
from her.
I'll sustain the objection. You probably need to lay a little more foundation as of right now.
Did you begin to monitor, as you began to monitor social media, what did you see that, did anything at all, that referred to or related to conflict between YSL and IFGAN?
Call for hearsay.
Overruled, sir.
Yes, sir.
Overruled. Overruled, sir.
Immediately after the shooting of, the murder of Mr. Thomas, when another shooting would occur, we would see members from both gangs posting disrespectful messages towards each other, tagging each other in posts, just so the other person would know that they're speaking on them. I do recall a post of, just as an example, a member of YSL was driving on the highway and members of If Gang shot his vehicle, basically chased him down. The following day, members of If Gang posted, just had a shootout on the highway.
She's speaking about.
Overruled the objection, sir.
The member of If Gang made a post of five of those guys. They were standing there pointing a firearm at the camera, and the caption was, just had a big shootout on the highway. What was his name? Lil Spaz hanging out the window, letting it ride sideways, which means he was hanging out the window, shooting a firearm.
Overruled, sir.
And that's exactly what the victim / member of YSL stated happened. The person was hanging out of the window, shooting an assault rifle at him.
And who is Lil Spaz? What was that person's real name?
Oh, geez, Adrian. Dalavante Fleetwood.
First name basis.
Was If Gang called up? Do they still refer to themselves as If Gang further into?
I sustain the objection to form.
I have to finish this question. May I? Your Honor?
Rephrase it. Just what you're.
Do you know whether If Gang referred to themselves as If Gang later on, past 2015? Or did the Atlanta Police Department recognize any other names that If Gang members began to call themselves?
To my knowledge, we knew them as Inglewood Family Bloods. Some members referred to themselves as Haiti Gang.
Was there ever a time where you became aware of anyone calling themselves YFN as a group?
Yes,
And when was that?
roughly 2016. I can recall.
So the rest of this day, personally to me, wasn't all that interesting. They really start steering more towards what they're going to talk about for the upcoming days, which is going to be, a shooting that primarily involved DK and Nard. So not that important. So we're going to skip this. We are currently on day 64. It was a half day anyway, so we didn't miss much. There was another break in it. Then they get up out of here. I mean, if you want to watch some surveillance, we can. If you guys just want to see some surveillance. Put it to normal speed. So here, this is going to be from April 12th, 2015. This was the Citgo gas station shooting with DK, Nard. I think there was someone else there too. I don't remember who. But DK, Walter Murphy, already did his time for this. And he got out. Let's see, we can watch that.
For the record, what the occupant of the silver Pontiac is found in relation to the second car that pulled in.
The gentleman who exits the silver vehicle in the front passenger seat, he's now appears to be leaning over, talking to the driver or occupants of the second vehicle.
And has the occupant, has either door of the second vehicle opened yet?
No.
And has either occupant of the second vehicle exited the vehicle?
No.
Continue to play. At 213609.840, how many occupants have gotten out of the silver Pontiac that drove in first?
3.
Is there another occupant near the gas pumps? And if you can't tell, that's okay.
At this angle, I can't tell.
Has anyone gotten out of the blue vehicle that pulled up after the silver Pontiac?
No. No.
Do you recognize anyone that has just gotten out of that silver Pontiac that's walking forward in the video?
Here, yes.
Who?
Kelvin Treadwell, aka OG Bentley.
And what area are they walking towards, the occupants of the silver vehicle?
The entrance to the food mart portion of the Citgo.
At 213617, has anybody gotten out of the blue vehicle?
No.
What about 213637? Anybody out of the blue vehicle?
Oh, don't ask me about cars.
No.
I don't know. I am not a 20-year Infinity expert.
At 213659, has anybody gotten out of the blue vehicle yet?
No.
At 213708, is there any movement from the blue vehicle?
Yes.
What does it do for the record?
It passes by the front side of the silver Pontiac, and it eventually end up over here at the opposite gas pump.
Now, a continuing objection, Your Honor.
As to what, sir?
Personal action.
And so the thing that's crazy is DK still has a conviction. So even if it seems like maybe that's not what happened, this isn't the trial where the facts are here to figure out to revisit that guilt. That's the crazy part. And it's crazy, it's really crazy to me that the state spends like 2 days with Detective Gaither on this. In different ways.
Personal knowledge.
I'm over, no. And not this time, sir. 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 213659, 21
At 21:37:14, what for the record is the blue vehicle doing?
It stopped in front of the silver Pontiac.
And what does it do initially, before pulling up to the set of gas pumps opposite the silver Pontiac?
It reversed a short distance and then pulled to the side of it near the, so the driver's side doors are next to each other.
At this point, have you seen anybody get out of the blue vehicle?
Not at this point.
At 21:38:02, what has the blue vehicle done since the last time that I asked you a question about it for the record?
Is now next to the adjacent gas pumps of the silver vehicle.
Is it directly situated?
Sorry, we gotta
next to
speed this
or
up.
behind and to the right of the Pontiac?
I stand objection.
Would you please, for the record, clarify exactly where the blue vehicle is in relation to the Pontiac at 21:38:02.705?
It's behind it and directly to the right of it.
Thank you. And are the brake lights on?
They are. Well, they were.
At 21:38:34 and 8:17, do you see anyone standing outside of the blue vehicle? Yes.
Doesn't appear, no.
At 21:39:05 and 3:55, do you see anyone outside of the blue vehicle?
No.
Continue to play. At 21:39:40, what, if anything, do passengers in the silver Pontiac do? Do you see any movement, for the record, of passengers from the silver Pontiac?
Yeah. Would you like me to say who that person is? Or?
Do you know?
Yes.
How do you know?
I later spoke with her,
Who is that person?
Miss Tina Clark.
And what does Ms. Tina Clark do at 21:39 and 48?
She exits the driver's side door and goes around to the actual pumps, gas pumps on the opposite side of the vehicle.
Do you see anyone outside the blue vehicle at 21:39:48.339?
No.
At 21:40:03, do you see anything as it relates to the blue vehicle?
Yes, you can see the brake lights come on.
Okay. Is anyone
Computer is
outside?
screaming at her.
Not at this point.
Are the doors open or closed on the silver Pontiac?
This time stamp, it appears just the driver's side door is open.
Kind of looks like the other one's still open a little bit. But what do I know? I'm like
At
blind.
21:40 and 13, what happens as it relates to the blue vehicle and its occupants? Does anything happen for the record?
Yes, the brake lights come off and the driver of the blue vehicle exits.
Do you see or was there anything in his hands like a long gun?
No, it does not appear to be anything in his hands.
And are you able to tell the jury based on your personal knowledge who that person is that got out of the car?
That's Neil. His first name is Cornelius. I'm
Okay.
not certain his last name at this time.
And that's at 21:40:15 and 8:70. At 21:40, 27, what do we see Neil do?
You can't see it from this angle, but there's vehicles parked here at the front entrance
Uh-huh.
of the store. Draw.
You have an objection, what's the basis?
How are we testifying to that?
Yes, I do.
What's the basis of your objection, sir?
Detective Gaither's not there, we need the honest information for this video.
Your Honor, we-
Yes, ma'am.
Your Honor. There are angles that have been. looked
Well,
at
then
that
ask
we've
her,
shown.
I'll stay in the questions to form, re-ask her, ask her another question.
As it relates to the front area of the store,
Mhm.
what do you see Neil do, as you were describing previously?
He just began to walk towards the front of the food mart.
Is he running?
No.
And as he walks towards the food mart, did you see evidence of anything in his hands?
No.
And now at 21:40 and 43.308, would you tell the jury for the record what Neil was doing?
He appears to be walking back towards his blue vehicle.
Okay. And where is he at 21:40 and 51?
The driver's side door. He enters the car.
Of the blue vehicle?
Of the blue vehicle, yes.
At 21:41:18.495, would you describe for the jury for the record what, if anything, happens as it relates to Neil, the blue car, and the silver Pontiac and its occupants?
You see Neil exit the driver's side door again. He's standing near the rear rear driver's side door. And the young lady that was at the gas pumps approaches him.
Is that Ms. Tina Clark?
Yes.
All right. And are you able to tell where Neil's hands are as Ms. Clark approaches him?
Maybe in his pockets.
I'm Virginia. At 21:41:24, where are Neil and Ms. Clark?
They're standing in between their two vehicles and they shook hands.
21:41:45, where is everyone that is outside the car?
Ms. Clark, she's standing at the driver's side door, and Mr. Cornelius is near the backseat door, driver's side.
And has anyone else gotten out of the blue vehicle so far that you can tell?
No,
Is any door of the blue vehicle open?
it just appears the driver's side, the front door.
Okay.
Ms. Lowe,
Yes.
you got another 5 minutes for the end of the business day, okay?
Then I'll let it play out and not ask any questions.
Glanville said, let's go.
At 21:42:23, where is Neil in relation to the occupants of the silver Pontiac?
The same spot near the rear driver's side door.
At 21:42:49, where is Neil?
It appears to be the same spot.
Is he talking to the same young lady?
He is.
Are there other occupants of the silver Pontiac on the other side of the car?
Yes.
All right, now, what, if anything, happened on the other side of the gas tanks where the silver Pontiac is situated just before
Gas
21:43:21?
This here, white Dodge Nitro, which we learned was a suspect vehicle, entered the parking lot and stopped at that side of the post.
Did it drive in slowly?
It didn't appear to be slow, no.
What does Neil do when that Nitro comes up?
He immediately walked back to his vehicle and entered the driver's seat.
And what happens to the occupants of the Dodge Nitro?
All three exit the vehicle armed with firearms.
At 21:43:28, have you seen Neil with any type of object that even resembles a firearm?
You can't even see Neil at this point. He's inside the vehicle.
At 21:43:32, what has Neil done?
He's got into his blue vehicle and closed the door.
And what about the occupants of the Nitro? What is happening at 21:43:32 and 8:23?
They're walking into the parking lot armed with firearms.
At 21:43:37, where is Neil?
Inside the driver's side seat with the door closed.
Has anyone from the Nitro done anything in relation to Neil's car at this point?
You can see this Guy here, later identified as Walter Murphy, walking up towards the rear of their vehicle.
At 21:43:48, is there anything you can see in Walter Murphy's hands?
Yes, you can see a assault rifle.
And what have you just done as it relates to the blue vehicle?
He approached the driver's side door, maybe less than 5 feet away. I don't know what the conversation was, but he raised the firearm and then began to back away from it.
Is his face covered, Mr. Murphy?
No,
All right. And what is he doing at 21:43:51?
he's attempting to conceal the rifle into his jacket
Okay. And where is he walking?
towards the front entrance of the food mart.
What is the blue vehicle doing?
Brake lights came on, so it appears that it's putting in gear to leave.
What's happening at 21:43:59 and 467?
Walter Murphy began to run towards the blue vehicle with the assault rifle drawn.
And what does the blue vehicle do?
Pulls away.
What does Walter Murphy do?
Standing in the parking lot having a conversation, short conversation with this gentleman who was an occupant of the silver vehicle.
And do you know who that gentleman is?
I do not.
Okay. At 21:44:06, has the blue vehicle completely exited the parking lot?
Yes, he went south on Jonesboro Road.
Did the blue vehicle creep off, or did it speed off, or did it do something in the middle?
It appeared to leave at high rate speed.
Where is the silver Pontiac at this time? 21:44:12.
It's still parked at the gas pumps in its original place.
Did you see anyone other than Neil get out of the blue vehicle while it was in the parking lot?
No, ma'am.
And how many persons are on the outside of either the silver Pontiac or the white Nitro?
From this frame, I can see 3.
All right, so we're about done for the day.
Yes, Your Honor. I stopped for the record at 21:44:19, 1650.
Yes, ma'am, so moved.
So there is that. Now, the same way that Gaither was narrating that video, she on separate days is going to narrate videos from inside the Citgo gas station. They spend a ton of time on this, and it doesn't involve any of these 6 folks sitting here in this trial. So with that, that was the end of, what day was that? 64? Day 65, we're not going to watch, it's long, but it's like all about, and a ton of breaks, but it's a lot about this Citgo gas station and DK and Nard. Not really relevant to these 6 co-defendants besides the overall conspiracy. But we're going to watch the beginning of day 65 because Brian still motions for a mistrial in relation to the way the witness was qualified in front of the jury after a interesting instruction from Judge Glanville. So we'll watch that quick, see how that goes. Some spicy Brian Steele. And put that on 1.5. Thanks for the super chat, Peter Ortiz. Yeah, definitely just a bunch of people hanging out at the gas station, doing almost nothing.
Your Honor, I took a lot of time to go through what is inconsistent. That's what I sent to everybody this past Saturday. I truly oppose it being played. Now I truly oppose it being played and then leave up to the jury to decide what is inconsistent. I'll be moving for mistrial, which I presume will not be granted, but I'll protect the record. And I don't think that the court should be giving a limiting instruction to tell the jurors to decide what is or isn't inadmissible. But here's the entirety of this recording. I also particularly and strenuously, I'm not waiving anything else, but I strenuously object. We had a hearing before Your Honor court about witness intimidation. There is 0 evidence that Mr. Murphy was intimidated, said he was intimidated by Mr. Jeffrey Williams. You granted that. I gave to the court and the parties cases that say, well, even if it's not a party, if it's that person's feeling, and that's why that person didn't cooperate or come forward or was not forthright, then that's also admissible, even though it does not, a threat does not come from the accused. But here, Mr. Murphy did cooperate fully. Within 30 days, it might be a little more. So from July 15, 2015, it's now August 18, 2015, so approximately 33 days. Mr. Murphy reaches out through his lawyer to the prosecution, meets with Detective Dennis and Detective Gaither for hours. And he informs them things about who was involved in YSL. He talks about several things, including April 12th, April 26th. April 12th is the Mr. Dexter Montgomery, Your Honor, I apologize using the date. April 26th is the tour bus shooting. He talks about the history of YSL as he knows it. He talks about what it's like in the jail. Several months later, maybe 6 months later, it's now February 11, 2016, the Honorable then former prosecutor Chada Jimenez, is now on video audio with, again, the lawyer, Mr. Hudson, Mr. Murphy, Detective Dennis, Detective Gaither, and there's a sheriff deputy, I don't know the name on the video, who I don't believe speaks at all. And again, he's cooperating. So to get in that he believed he'd be killed and threatened is just the state's way of trying to, and they've already gotten it out of witnesses, that they won't cooperate, that they feel threatened, that there's a stranglehold on them. You heard it last time that Detective Gaither testified over objection. You heard it with Detective Belknap. So I hope that the court would grant the motion, which I thought you granted, that these are targeted issues. This is not a free-for-all, play the recording, and then somebody else will make a decision. The court makes a decision, what can be impeached for prior consistent statement, and then please exclude, my request is again, which I believe you granted, exclude any mention that Mr. Murphy was in fear, because it goes to tremendous prejudice.
Well, I think that the case law that you indicated, I agree with you about, but I think that the state's rationale as to why he's made those statements is different than the case law. So for that reason, it's relevant for the jury's determination for what they want to consider.
Well, respectfully, and I hear respect all the time. I mean respect. I'm not trying to bump up against the court's thoughts, but I just respectfully disagree, and I will maintain what I gave you. If you can mark it as a state, as a court exhibit, I went through that. Was a lot of work. Went through in the red, which I believe, in good faith, is the only inconsistencies. Now the state wants to play the entire tape. I never expected that to happen. I never thought you ruled that out.
No, I don't think the state wanted the entirety of the statement as well. But I believe that under U.S. versus King, that's what they're saying, or they're asking the court to play his statement for that purpose. So to that extent, I'll let it be played over your objection. I'll give you continued objection on that issue. Okay.
Thank you.
All right. Mr. Sharp?
Yes, sure. Yes, Your Honor. Three things. First of all, we still haven't gotten we're all referring to this US v. King. We still haven't received a citation for it. So I don't know who's been able to review it, but we need a citation for that to even.
Ms. Hill, do you want to give us a citation again?
We're going back to Steele.
The way I understood it is different. The court made that determination without the hearing, and then
Which I didn't need to do, and you all disagreed. I get it. You the opportunity to voir dire the witness before the stay to it in front of the firearms to find someone. No, it wasn't, but there was no pre-admission. It was done in front of the jury because of the type of case it was. I think it was a firearms or ballistic or whatever else. And Mr. Steele, I think the court just made that finding anyway. I'm objecting to it in front of the jury. I'm objecting not to having a Daubert hearing outside the presence of the jury. So, state, lay the foundation for Detective Dennis to testify as an expert. The court also read the admonition as to an expert and fact witness before this witness testified. I gave all of you the opportunity to voir dire the witness before the court made a determination of whether or not she would be tendered and qualified as an expert. None of you took the court up on that because up to that point in time, I had not ruled that she could be qualified as an expert. So, Mr. Steele, I'm in possession of your motion. I don't believe it's timely. I believe it's waiver. I believe you still have the opportunity to cross-examine Detective Gaither about anything that she may have in terms of her investigation of this case. So, for that reason, I'm going to deny the motion at this point in time.
may I have a moment?
You may have two.
Your Honor, I believe that the court is misunderstanding the sequence in paragraph 5 of my motion to strike Detective Gaither's testimony. The sequence is as follows. The court, outside the presence of the jury, I believe the night before, maybe earlier that day, I don't remember, did exactly what you just read, and denied a outside the presence of the jury Daubert hearing.
I did.
Then what happened is...
And that was because we're allowed, or in the court's estimation, even though we may disagree, I believe that gang expert testimony and this particular witness's background would lead her to be qualified. But you still had to, the state still had to do that in front of the jury for me to make an expert determination.
So my saying where I understood it is different. The court made that determination without the hearing, and then
which I didn't need to do, and you all disagreed. I get it.
So anyway, the way then sequentially, this honorable court, as Detective Gaither was about to testify, gave that instruction, which you gave 2 times previously, about Detective Belknap, saying that this is a dual witness. I don't have to repeat it. I presume you know what I'm talking about.
Yes, sir.
When you did that, and then the state is qualifying Detective Gaither, I, Brian Steele, stand by. I'm not accusing this court, and I'm certainly candid, always got willing to the court, but I took that as...
No, but that wasn't. You had the right to voir dire the witness before the state proffered her or accepted. The court said she was an expert. You had the opportunity to fully examine her, because you know what would happen if they would not have qualified this witness pursuant to Daubert in 702. I would have excluded her. You would have probably moved to have her excluded as a witness, an expert witness, which I would have granted. But that didn't happen. And I asked all of you whether or not you wanted to take advantage of that. So
What I'm trying to say.
you waived that issue at that point.
What I'm trying to say is to ask the questions in front of the jury, the probing questions that this honorable court has allowed on every other Daubert witness.
But why didn't you do it? I mean, because you could have done that. And that was the danger for the state asking me to do that at that point. Because had they not gone ahead and qualified that witness, they would have fallen flat in front of this jury, not having a witness that was qualified.
Well, I would have fallen flat in front of the jury because I would.
But you had that right, sir.
I'm just trying to get out my statements. The questions I would have asked are occurring in front of a jury. It would have asked her a basis of knowledge. Where is the gang book that we don't have? That she's relied upon, that Detective Belknap relied upon, that we can't, for whatever reason, I don't know.
I think nobody's actually brought a gang book as of yet.
But you told me, I asked for it, you told me
If they have it, they need to tender it, yes.
I have nothing.
And we just heard them ask the state for that same thing this past week, all the way in August. We're at the end of August. Now, the reason this is so relevant here now is, oh, Judge Glanville saying, oh, you acquiesced, you didn't object, you had the opportunity to object. And Steele saying, well, I couldn't just get up in front of, you're doing this in front of the jury. So the questions I would be asking, you put me in a tight spot. But if anyone paid attention to the State v. Riley case that Brian Steele just argued in front of the Georgia Supreme Court this week, we saw him specifically wait, or not in that instance. He's done it in this case. He wants to wait to raise an issue with the indictment in this case because he wanted double jeopardy to attach. He wasn't the trial attorney in State v. Riley, but he makes an argument that if the trial attorney had raised the issue with the defective indictment before the jury was sat, then double jeopardy wouldn't have attached, and that it would have been ineffective assistance of counsel. If you heard Brian Steele in this argument that we're watching right now on day 65 relating to the qualification of Detective Gaither, his remedy that he's asking for is to strike all of her testimony. So it's almost like he took a gamble. Now that I'm like learning more about Steele, I feel like back when this was happening, he took a gamble, waiting to rely on this case law, saying, all right, we're going to let her go. And then we're going to move to strike it. And then that's it. They get no more. I think he strategically waited. And it didn't play out because Glanville didn't agree with that. So there were two options. He chose one. It was probably a bigger risk with a bigger reward. And he lost.
I would have asked the questions specifically about Mr. Williams and how you separate, just like I did with Detective Belknap. How do you separate a law?
Aren't you going to cross her on as to that?
No, I'm not going to cross her. I already did it with Detective Belknap. I don't have to repeat. So my point is, there was absolute candor always with the court. I did take it to fait accompli. I don't know why.
No, but that's not true, sir. And that's a misstatement and a mischaracterization. You're telling me that I've already made up my mind at that point in time. It was all but a certain conclusion. It was not, sir. That's not the way that this court looks at its role as the gatekeeper and its role as a referee.
I understand that you're offended.
I am offended because it's not true in terms of what you were given.
Well, I'm going to tell you I'm offended because no other time in this trial have you given a instruction to the jury before you found somebody expert to say this person is going to give expert and lay testimony. So as a listener, it was already a fait accompli because you already instructed the jury that that witness was going to provide expert and lay testimony.
Did you object at that point in time?
Your Honor, I believe.
Did you object at that point in time?
I believe you already.
Did you object at that point in time, sir? I'm asking you a question. Did you object to at that point in time saying, Judge, she hasn't been qualified as an expert as of yet? I don't think you should read that.
Technically, the defense objected with that process happening in that order. So how is that not the objection? For this particular argument, the defense did not want that to happen. They objected to going ahead with this Daubert right in front of the jury. So I don't understand how Glanville's asking him, did you object at that time? Because all of the defense attorneys had.
That instruction as of yet.
It would have been frivolous to say.
But you didn't object, though, did you?
Listen, I'm not playing.
I know I'm not. I'm asking you. Look,
I'm just saying to me, there's nothing but candor in my motion always with the court. I love this court. I'm not attacking you. I'm telling you how it appeared to a reasonable person.
Sure, but that's not true. That was not true in terms of the way and the what you have been given. This case. The court made a ruling. Like I said, I rule the way I see it. I mean, I have no interest in this case. In fact, I tell the jury that when I charge them, I don't.
Your Honor, I cannot find another case. The Daubert hearing was held in front of the jury. I cannot find it. So anyway, my motion.
Okay. All right, sir.
My motion goes much deeper. You just took one paragraph, which I stand by fully. But
and then
nothing here. I'm sorry.
Go ahead. I'm sorry. I apologize. Go ahead.
Nothing here. You know, I listened to the testimony of Detective Belknap. I looked at my notes. I had other people do the same. Look at their notes. I then checked it online because I know it's not official, but there's a video of this trial.
Yeah, it's daily.
I then looked at Detective Gaither's statements and testimony as my notes. I asked others, and I watched that online. Your Honor, there's no need for this witness to be an expert. All she's doing is corroborating and supporting her coworker. This is like a vouching improperly. This is like another summation
Bolstering.
that's coming from one of the case agents or lead detectives who is saying the exact same things. You've heard nothing. I challenge it. I put it in paragraph. I put it in 2 different paragraphs. I put in paragraph 6. Put in paragraph 6.
And we'll finish out Steele's argument for sure. I think I love responds. If you guys want to watch that, let me know. If not, we don't have to. But here I do want to clarify abundance and clarity. I want to clarify something for abundance and clarity. So unfortunately, Steele was wrong in this situation. He took a gamble because he was relying on case law. And depending on the judge, this is why I say it was a huge risk for him to have, tried to take this route. I think it's a risk in front of any judge to hope judge agrees with the point you're making and the strategy you took, especially if it's kind of a new argument that judges aren't used to hearing. But he took a great risk because he's making this argument in front of Judge Glanville, and within Judge Glanville's discretion, he's saying, nope, I don't agree. So, and maybe it would be a appealable issue. Maybe they would find that that was outside the bounds of Judge Glanville's discretion. But then there would have to be a test for whether or not the error by Judge Glanville allowing the Daubert hearing in front of the jury in this manner was harmless error or harmful error. So even on appeal, it's still a gamble, gamble, gamble. The golden prize would have been at that moment having a judge agree with you and saying, oh, okay, guess we got to strike that testimony then.
And 7.
Yes, sir, I see that.
Gaither is giving the same identical testimony as when you qualified Detective Belknap. So I moved to strike the testimony because it is repetitive, cumulative, and prejudicial, because these people, these detectives, being couched in expert and lay testimony, there is a real significant danger that the case law tells us about, that they will have an air to them to give basically multiple summations or closing arguments for the state. It's called an AURA, A-U-R-A, or special reliability and trustworthiness. Now the state wants to do it 3 more times with Detective Underwood, Detective or Investigative Marito, and Detective Dennis. Because I have no report on any of them why they should be different, and the Honorable Court did order their gag experts.
I did, but remember, we've gone down this road several times already. If they prepare a report, you'll get it.
You wrote in your order, it's November 17th. Please check it, because if I'm wrong, I'm not trying to be wrong.
No.
I'm going by my memory. It's November 17th, 2023. I see it in my mind's eye. I have this great memory. It's in the very bottom last paragraph. And you wrote that all reports, including gang experts, they must be written. So this way we understand what is the difference between 1, 2, 3, 4, and 5. And instead, what I'm getting, Your Honor, as a viewer and as an advocate in the case, is I'm getting an unfair trial because it's repetitive vouching, bolstering. I don't know, but it's the state's theory of the case. When a person became a fact witness and an expert witness, and then you allow a rejection, the state to say how they did their investigation. And when I retired, it was still ongoing. And we noticed that people wouldn't speak with us. This is everything you hear when a prosecutor gives her summation or closing argument.
But that's part of the investigation. I mean, that was, and the jury's free to believe or don't believe this. I mean, in terms of the backstory of this particular case or how it developed, which the state has to prove.
The investigation in every.
I do always hate when they lean on, well, it's the jury's job to decide what they believe and what they don't believe, because the issue with bolstering is kind of tainting someone's perception. You have 4 current or former detectives, people in uniform, come in with a higher trust. They're more likely to be trusted, at least during voir dire of the jury, not of an expert witness. You know, the state is probably looking to weed out people that don't trust law enforcement because they know they're going to be calling law enforcement as their witnesses, detectives as their witnesses. So at this point during trial, when you're calling 4 people and you weeded out anyone on the jury that has a inclination towards distrusting a police officer or a detective, typically, psychologically, people are trusting the person that sitting up there with the badge unless they're given a reason not to. So when you have 4 people with the badge with the same training coming up and giving cumulative testimony, it's layers of bolstering. So at some point, it's not just the jury can just decide. They're in their own vacuum, and they can look at a duck and decide if it's a duck or if it's not a duck. But they have 4 people repeating that it's a duck with the same knowledge base. 4 people repeating that it's a duck when that's cumulative, and there could only be 1 person. Now, I think you guys all understand in the chat the difference if 1 person's saying something versus 4 people are saying the same thing. People tend to believe, and I argue with people on this all the time, just because more than 1 person says something doesn't mean it's true. But typically people are inclined to believe when there's a volume of people, the higher quantity of people saying the same thing. So this is why, and it's a little bit hard to follow Steele sometimes because his brain works at like 1 million meters a minute, and I'm sure this is very emotional for him. Watching him argue in front of the Georgia Supreme Court, he was a bit calmer. It wasn't his case. It wasn't his client back during trial. He wasn't arguing with the judge. They were more having discourse. But here you see him weave through 4 different things. And when you see the other attorneys here make arguments, they're pretty much focused on one grounds, one basis. But here he weaves it all together.
Case is irrelevant. It's the conclusions, the results, but how they go about it. Today we watched this home and we saw Jeffrey
It's
Williams
a quay,
come
not a
out.
quack.
We saw Jeffrey
Or a
Williams come out of the
quack.
home along with a co-conspirator. They were carrying choppers. That may be relevant, but that's not what's going on here. It is. We saw this uptick in crime. There's a war going on. I'm objecting to these things, but the jury hears them. That's my position.
Okay.
And you know, paragraph number 5, the way it came out, the sequencing of it, that person's already qualified. The sequencing, because otherwise, why give that instruction that you're about to hear from this expert and lay witness, and you have to.
Well, that would have been a challenge for me at that point in time, but you didn't object to it. But yes, you're absolutely right. It probably would have been something that I would have probably had to think about. So yes, but I still gave you the opportunity to voir dire the witness and make that particular record prior to my ruling.
And I've waived that opportunity intelligently, knowingly, because the jury was here. But I did ask you if I could have a out of the presence of the jury hearing to determine expertise, and you said no. And it's all on the record.
I know that, and I made that decision. I did.
And then I
did.
make the corresponding decision. And Your Honor, with that being said, I would like you to strike the former detective Gaither's expert testimony. It is nothing but cumulative. And I would ask you to please put on your docket time that we can understand why are we going to have potentially 3 more similar experts.
If you then file a motion on that, and look, when
It's a motion to strike. In the motion that you're referring to right now, it's a motion to strike purported expert Gaither's testimony and to prevent any additional expert or
That right there, Glanville skim read it and forgot that Brian Steele will put 4 or 5 reasons in a single motion.
quote testimony from supposed gang experts from the City of Atlanta Police Department. The reason is we're not having like an expert from Canada and then an expert from California and then an expert from City of Atlanta Police Department. These they should all be the same. They work together. It's like saying Keith Adams and Brian Steele. You put us up, we're gonna have the same ideas on this case. You know, we work together. So it's, you know, that was my.
all right, sir. Okay.
I want to thank you, and I hope you now understand.
I understand, sir. I do.
That I was not.
I do. I understand the other basis for your motion. State.
Thank you, Judge. With
Just want to hear the response.
Mr. Steele's argument regarding the timing of the court's instruction to the jury as to the dual basis for the witness, Your Honor, we did not ask for it to be done at any particular time. We actually, at one point, I think, asked that it be done at the transition mark. I believe that Mr. Steele, as the court has properly alluded, waived his opportunity to have that particular instruction given after the court had qualified her as an expert. I believe that out of an abundance of caution, the court was letting the jury know that this witness may be giving expert testimony as well as fact testimony. I do not believe that the court said anything that definitively made a statement regarding the expertise of a person the court had not yet qualified. The court is correct. There's not even a need to hold a Daubert hearing at all. Certainly not. It is not necessary to be pretrial, but here we do want to make sure that these matters are attended to so that there is no issue further down the line. And I believe the court properly handling and qualifying this particular witness as an expert. Secondly, as to the motion to strike the testimony because it is cumulative, I see no legal basis within the motion that Mr. Steele filed for any such draconian act on the part of the court. I will say, however, that of the 2 experts that we have already qualified, because notwithstanding his assertion that we've done 5, we've only qualified 2, and we've only presented the testimony of 2.
You
Those 2
guys.
experts have 2 very different backgrounds. They are testifying about 2
The
very
chat's like,
specific
no, no
sets
more
of
love.
facts that are different. For instance, Detective Belknap interacted with Trontavious.
How long does she go?
He saw and spoke with Trontavious Stevens about what was on his arm, what was on his hand.
Oh, they take a
Detective
recess after it.
Belknap's Investigations.
Of course.
And Detective Gaither's investigations. And so not only do we have a different background for the experts, a different set of.
All right, it looks like it's 10 minutes of this.
We also have a different set of interactions to which they are able to tell the jury, about which they're able to tell the jury, and about which they can form their opinion, and then inform the jury as to their opinion. Your Honor, the notion that the fact that we have more than one expert in a particular area, because this particular indictment spans a long length of time and a large number of acts, in no way makes either of the experts that we are tendering irrelevant or cumulative or inadmissible. So we would ask that the court find that the court has ruled on many of the matters that Mr. Steele has in his motion, and that this motion is really a motion to revisit the court's prior ruling. So we ask that the court dismiss that motion on that basis.
What about the report? What about Mr. Steele's assertion that there's no report, it's repetitive, it's cumulative, and it's vouching? Because some of the stuff does have overlap.
2 things. I'll start from the bottom and work up. Repetitive, cumulative, and vouching. None of what this detective says comments on the veracity, the expertise, the anything that Detective Belknap said. We won't be overlapping when they are working at the same law enforcement agency. Some of the training that they experience, some of the people that they encounter will overlap, but their experiences are unique to each expert themselves. And if it were the case that we had 2 experts talking about the same exact set of facts, giving an opinion about the same set of facts, and they had had the same training, experience, and background, perhaps we'd be in a different circumstance, but we don't have that at all. As you can see, Detective Belknap's training was very much classroom oriented. He had training in the field, but his training was heavily weighted and slated towards the hours that he has received of specific game training via GGIA and other sources, whereas Detective Gaither received 40 hours, and then she has been clear throughout. The majority of her training has been her interactions with the people in the community, her interviews with, contact with actual gang members who were freer to talk to her because of her proactive policing style that she has employed since she began with the Atlanta Police Department at the Zone 4 Evening Watch Patrolling Unit. So where a jury has to make determinations about critical elements of each.
Wait, do you guys want to see her 2 times? Hold on.
Crime in this indictment. Your Honor, the state is not, we cannot shun our duty to make sure that we give them enough to be comfortable with making the decision, especially when we don't have people testifying about the same set of facts. The fact that these investigators came from the Atlanta Police Department, but they are not the same people without the same experiences, in no way should disqualify them as experts in allowing the jury to hear them. We heard how Detective Belknap was cross-examined. He was asked questions like, did you ever check out country music stars? Did you ever check out pop music stars? Things like that. With Detective Gaither, they may have a different set of questions for her, primarily because her whole experience is entirely different. So for that reason, Your Honor, we would ask the court to deny the motion to strike.
What about the no report?
The no report.
I did ask that, you all tender a report to your experts, to include the gang experts, so.
Your Honor, throughout the discovery process, we have turned over to counsel for defense various reports, and most notably throughout the operation planners investigation that Detective Gaither spoke about, there was, and it was given to the defense, and there was a summary of.
Imagine Weaver having to transcribe at this speed.
Exhibit EX1, just one example, and I'll give to counsel for defense a copy as well, whomever wishes to see it, I'll place it up here. Just would anyone like to open?
Yeah, I believe that was already discussed. I think I may have made a court exhibit earlier in regards to what, because there was an objection as to it. And I don't believe you said you all were going to tender it. You were going to, talk about the information. So, and I ruled upon it accordingly.
Your Honor, I believe you asked.
Say again?
I believe you asked about reports given to the defense authored by Investigator Gaither.
No, I just said reports.
Okay, well, this report that's being handed up to you is not authored by Investigator Gaither.
Okay, all right. So, all right. Okay, but back to my original question about reports. Is there any reason why Detective Gaither did not author a report?
Yeah, tell us.
Your Honor, the summaries of the investigations that she did that are included within the discovery that we have given to the defense, it includes her conclusions, her thoughts, her opinions, her observations on the members of YSL that she had an opportunity to impact. So, in as much as the investigation itself contains many of her, summaries and writings and the like.
Then that was turned over in discovery already, correct?
Yes.
Okay.
They have from Detective Gaither, they're reading, the reason they can know what she'll talk about is that they've read her reports throughout that investigation. And those reports essentially are bite-sized areas and summaries of what she's giving testimony on right now as it pertains to what she was able to observe in the field. So they cannot argue that there's any surprise by anything she said. They're aware of everything she said. And we've given to them the reports.
I'm going to ask a question that maybe, I mean, I've been a jurist a while, but I don't believe when we hear from gang experts, they usually have a report.
They have not had.
I haven't had one in my almost 20 years as a superior court judge.
And I would also say, Your Honor, that typically reports are generally from people who don't have that firsthand knowledge and who were not any fact witnesses. This is a situation where the expert is also a fact witness to the events that he is giving an opinion about and testifying about and has written reports about throughout her investigation.
Okay, I have one more question. How many more experts do you plan on calling?
I believe that we have three.
Which are?
That would be retired detective Tyrone Dennis, retired Detective Underwood, and Investigator Burrito.
Burrito. We've already had and our.
The burrito instead of Marissa Viverito is hilarious. We're gonna call Detective Burrito.
I believe that we've had Daubert hearings on all of them. Two of them. Who would we not have Daubert?
Actually, I'm sorry, we've had hearings on all three of them. Ms. Hilton reminded me we did have we had all three of them.
Okay. All right. Okay. Mr. Steele, I'll invite you to expand your assertions in terms of the other three witness experts that purportedly are going to testify, Detective Dennis, Underwood, and Viverito. I'm going to need to see more in order for me to rule on whether or not they are in fact cumulative or repetitive. But I am going to tell you all as a state that some of this stuff is repetitive, and and the court's not going to let you just go through it in whole cloth over again. So you need to be since a foundation's kind of been laid already as to some of this, it needs to be more focused. The next three folks. But Mr. Steele, I'll authorize or allow you to, if you choose to do so, to go ahead and by motion present to the court what you believe that the state is already or the issues with these particular three witnesses. Okay.
Thank you.
Mr. Steele, did you? All right.
Yes, sir.
Okay. All right. As for the motion at this point in time, in terms of to strike the testimony of Detective Dennis, Detective Gaither at this point. I'm gonna deny at this point in time. I'm not saying that I won't, of course, reconsider it, but I need to hear the rest of the examination as well as any cross on this. So, okay.
Okay.
All right.
And by rest of examination, this is 1 hour in of an 8-hour day, and then there are 2 more days before we get to cross-examination. So we are going to break here for this stream. We are not going to watch. There's like one snippet I definitely want to play. But we're not going to watch those, like all of this. We're not going to watch the next 2 days. They really, really, I'm not kidding you guys. They focus on DK and a little bit of Chontavia Stevens or Slug. Their DK's jail calls, some interviews with him. He's snitching. But I think maybe next weekend, because tomorrow I think I want to do another live stream and we'll watch the cross. We'll like speed ahead and just start with cross tomorrow. And there was about a day of cross and some redirect from Love and then some recross from, I think just Brian Steele did recross with Detective Gaither, if I'm remembering correctly. But really good stuff with cross and the redirect and recross. So that'll be fun to watch. That will be tomorrow's stream. Next weekend, maybe, depending on... That's Labor Day. I mean, I don't think I'm doing anything, but who knows? But DK is one of the witnesses I would like to go back and watch. We won't watch it from start to finish. We'll speed some things up. We'll condense it down. That way anyone who either wants to revisit it or never saw it at all can get a decent idea of what it looks like when somebody gets a plea and then they're brought in to testify and then they're still pretty favorable to the co-defendants on trial and not really that helpful to the state. So we'll look back at that. Again, this week on Monday. Monday's going to start with the jury back in. Kenneth Copeland should be on the stand. They do have some video, a couple hours of video, hopefully under 2, left to get through of that last police interview with Woody. And then Hilton says she doesn't have that many questions to ask him after that, but who knows? They also had IT issues on Friday, so who knows if they have to deal with issues before the jury can come in on Monday. But the expectation is that cross-examination will start on Monday. Hilton expects to pass Kenneth Copeland to the defense early afternoon is what she said. So Monday morning we'll be streaming live on time. I'm not going to start late and then try to catch up. We're going to watch it in real time on Monday. Tomorrow we'll watch cross-examination on our throwback of Detective Gaither's testimony. And if you guys are looking for stuff to do tonight, this is the link for the remainder. You see how much is left here of day 65? And you could check out day 66 and day 67. I think those are long days too, tons of videos to go through if you want to watch that in full. But other than that, we're going to really get right to that cross-examination and go through that on tomorrow's stream. Thank you so much, you guys. And I also saw, I didn't see it earlier, and I want to get your name right, because with the capital K, I want to say Trakisha. But is it Trakisha? I want to say Trakisha, and not Trey-Keisha. So my guess is Trakisha. And I want to get it right. And I want to thank you for setting a cash app. That was super, super nice of you. And I think you're still here, so I'm going to wait to see if you give me the hooked on phonics. Trey-Keisha, okay. There we go. So Trey-Keisha, I got it now. Perfect. So thank you so much again. And whatever you're doing with the rest of your Saturday, or some of you it's probably Sunday already, enjoy it. We will, I don't know what time tomorrow. Maybe kind of same time tomorrow. We'll see. Till then, you guys all take care. Have a good one. Bye.